clearly can't be in the courtroom. So it's unclear if anybody's actually in the courtroom to protect Copeland, even though they had someone in there yesterday. So maybe that's why he's changing his tone, answering a little bit differently. Thank you so much, Garrett. Carson, this is funny. Woody has single-handedly crashed closed captions. Now, those are wrong a lot, but they have been extra entertaining, trying to keep up with the things that he's saying, for sure. And then Carson also said that the state's star witness is a professed liar. And not just a professed liar, but lie all the time. I lied about that. I lied about this. Probably lied about what I told you the other day. I don't ever tell the truth. I lied to the police. That's what you're supposed to do. That's how I grew up. Thank you so much for your support, Carson. Cutthroat went all the way there. Cutthroat says Hilton's up there looking like Barney. Well, there's no green underneath, right? She's not wearing a green shirt under it. I actually thought Love's coloring with the ruffles was kind of nice today. But she's off screen, so it doesn't really matter. Thanks for becoming a member, Pierre. And then, yeah, Pierre says they need more street smart state questions. And when I saw this comment, it got me thinking, what were these one-on-one conversations like between Hilton and Woody? Like, where she was trying to build rapport with him. What was the vibe of those conversations? Because I can't imagine Hilton actually building rapport and actually truly relating to Kenneth Copeland, especially not after yesterday that, oh, I'm sorry for your loss, and then moving on, like that disingenuous, I'm sorry for your loss, when it was mentioned that Brett was killed. She just, what kind of rapport do you have with somebody if you just give a weak, disingenuous, I'm sorry for your loss? But yeah, thanks so much, Pierre. And then also, Mr. Copeland, everything you said in all the interviews about my client was a lie. Defense passes the witness, Your Honor. No more questions. I mean, it could be effective. I'm sure from some of the attorneys we'll see that. Max Shart, it's stylistically his style to be a bit more long-winded with his questioning. Plus, the things that Copeland said implicate his client pretty strongly compared to some of the other co-defendants. So, for specific charges, not just, overt acts or RICO as a blanket. So I think with Shart, we will see some longer questioning, and he's got to be careful. He might have to be a little bit careful with that he doesn't say the wrong thing, have the jury too focused on something. I'll be interested to watch how Shart approaches this, because that's a big deal for his client. But yeah, I think some of the other attorneys, we might get some concise, all right, one question, couple questions, quick answer from Copeland, and that's all they need. Dave911 says, me no speak no English. I'm spewing my drink if he says I don't recall in Spanish. I think the chat started saying it in Spanish. Thank you so much, Dave. And then Peter, thanks for becoming a member also. And then Eternity said, Whitaker, this is not what I signed up for. Yeah, I really don't think she's going to enjoy if this direct questioning keeps dragging on and on and on, and she starts to suspect that we are not going to get done with direct examination by Friday. I do not think she's going to be okay with that. And again, the reasoning is the fluidity of the case, the scheduling, the speed at which we're moving, the efficiency. I don't think the issue will be any other thing but that. Thank you, Eternity. And then Sandmon, always love that owl picture. Thank you for the $1.99. And yeah, so again, this Melnick story is tearing us up today. So Melnick was suspended, but it has nothing to do with this case. Nothing to do with this case. The timing might be really coincidental. He absolutely was suspended. 6 months. The Supreme Court of Georgia released their decision today. So that's why he was able to be in court yesterday, but he's not in court today. It's an instant, it applies instantly. It will automatically be reinstated when the 6 months is up. He doesn't need to do anything. But it relates to a separate case. 2019, he wasn't telling his clients when they needed to appear for a court date, or a client that they needed to appear for a court date. So it is true, and it's shocking because of the timing of it. But it's still technically not related to this case. And so thank you for April Pitts on that, and also Clock It Got Him. Attorney, I still think this is a good theory. Thanks for the super chat. Hilton's buying time until next week's delay. And Blue Sky says, what criminal witness has really cooperated on the stand? I think it's tough, but I do think there are people that actually act like snitches. And, Woody's definition of snitches, I think, is really accurate. You're not really a snitch if you're a liar. You're a snitch if you tell the truth, that someone doesn't expect you to go and tell somebody else, right? So I think there are actually a lot of cases where you get snitches on the stand, which might be a little bit different than, I'm a criminal that lied to cover my own butt and then I'm still lying on the stand. I'm obviously not going to cooperate because it still benefits me to continue to lie or be unclear or point in the other direction. Because I still don't want a target on my back, even if maybe I have immunity and someone tells me I'm good, that it's fine. Because even if he had blanket immunity, feds can't touch him. Let's assume that. Someone else could. Someone else could get mad. Yesterday, he was concerned that Threat's family would be upset if he started talking about Threat. And that's reasonable. So I feel like it's more likely for an actual snitch to cooperate on the stand than for someone who lied and actually participated in criminal activity that somebody else is getting blamed for to cooperate on the stand. Because they still need to be careful that they don't trip themselves up, get themselves in hot water, put themselves in the line of fire of street justice, and what have you. So thank you, Blue Sky. And Terry Hobson, I think this is true too. So he's actually messing up talking about Woody by getting emotional and giving drops of information. They're going to use it to bring in other things. He's not the only witness. That's why I think when we get to Detective Dennis, especially since we heard yesterday, Love thinks she should be able to and clearly plans to bring in that Operation Planters PowerPoint. We're going to see more of this stuff. And what they're really going to try to do is just find one or two pieces of information that if Woody was saying it back then, it would be highly unlikely that he was just making that up. So if he was saying it back then, the other things he's claiming to have made up, if he got this weird little detail that someone probably wouldn't just conjure out of nowhere, he might have also been telling the truth about the other things he said in these interviews. So that's the angle the state's trying to take. It really depends on their organization with the future witnesses if they're able to do that. I think they can find a way to use a statement that Woody gave one way or another. But will they actually cleanly and in an organized fashion get another witness to tell the story in an organized manner that the jury will digest it? So thank you so much, Terry. Garrett says, Hilton's new Emory class is how to blow a case in a day. That sounds like a fun class, actually. I think it's really effective to learn from other people's mistakes. So it might actually be a good class. Thank you, Garrett. And hold on. Have you seen Woody's 2020 music video? Lil Woody Homicide. It's of him and Threat quacking nut. It's on YouTube. It's very interesting. Let me go and watch some of that stuff because a lot of the footage I've seen was just like general clips of him in a video with a bunch of people, and they're making, they're doing the hand gestures like they're shooting at somebody. But definitely didn't go out of my way to listen to any of the lyrics, so maybe I should do that. Definitely think I'll do that. So thank you, Michelle. I'm going to keep this one starred so I remember. And then Patrick Taylor says, does Woody have help there today? I don't know. I don't think he does. Does Woody have help today to help with the asked and answered? And all the slightly rephrased questions. That's why Woody's losing his short temper. I do think that this is why we're getting a slightly different. The joke is that he woke up feeling different today. And I think it's because he might not have an attorney there and he might be questioning what he might have understood his immunity covered yesterday. Like, just crazy. I don't know. And remember, it was a big deal to Glanville to have him represented. And now my guess is that he's not sitting there with representation in the room with him. And now he's saying, I'm innocent of everything. Like, Albert says, since Hilton deemed him hostile and has stated everything he said to detectives in the interviews, won't the videos be cumulative? So, a little bit, but at the same time, there is a difference between showing the demeanor, right? So, and honestly, even with an audio, there could be a difference. It could add something new. But seeing the demeanor of when he said it, there's extra things that the jury could take away from it. So cool, she's read the transcript, but the transcript doesn't give that context. So there is a way that if someone does object that it's cumulative, they just need to argue, well, no, it shows how he's sitting, it shows how he's throwing his arms up in the air. There's things that they can get from playing the same statement through the video that they couldn't get through the transcript. However, there's still the question of, what are they going to ask to bring in? What specific parts? There's no way. I would be so shocked if Whitaker allowed them to just play a long spans of video. And again, I say that because Whitaker likes time management. I'm not saying that because of how I think she would apply admissibility issues using her discretion. I think it would just be to not waste time with this long video playing. But I do think that a judge would side with someone saying, look, this video, unless there's something prejudicial in it, if it shows demeanor, it would add something that just reading the transcript wouldn't show and will allow you to play the relevant segment, the short and concise segment. So thank you so much, Albert. Cam says the cross will focus on him being coerced into testifying, making sure the jury knows why this has taken hours and redos. And why? I mean, I get that he said he's innocent of everything today suddenly. If I was the jury and I remembered him questioning, like, am I protected? Can I say this? Yesterday, I would just assume that he was saying he was innocent today because he was worried about being prosecuted for something he told the truth about yesterday. I would think his sudden switch bolstered what he said yesterday. And as a juror, you have the right to weigh things how you want to weigh them, how you think that they should be weighed, what you think is credible when or why not. But I do think if the defense gets up there and the larger part of their questioning is back in June, those things you were saying in June, why is how you testified in June, not all the way back to police in 2015, but June of this year versus July or August. Why were you a little bit different 2 months ago? Oh, you maybe felt coerced. You were in a room with a bunch of people. You tried to tell the state about the infinity, but they didn't want to talk to you about that. In fact, they didn't really want you talking much about what you told us on August 12th about Donovan Thomas and about threat in Donovan Thomas. They didn't want you to talk about that stuff, did they? Did you get the impression that if you talked about those things, you would be charged with perjury, which you're not protected from, right? You understand it's a compound question, but you understand that you're not protected from perjury, right? So did the state tell you that they would charge you with perjury if you talked about certain things? Okay, what were those certain things? And I do think that Copeland will be forthcoming in answering questions like that. I really do. I mean, I don't see why he wouldn't be. And that could be really effective because that would obviously explain to the jury why we haven't been here for 2 months. Like right now, they might just think they're not there because something happened with Glanville. He's sick. I don't know if they see him like entering the court and they're like, well, Glanville's fine. He's still here in the courtroom. I don't know. But it would make it a little bit more easy to confirm in your own thoughts. Like, oh, the state messed up and did something. That's not good. So yeah, definitely interested in seeing Cross. Thanks so much, Cam. Iron Rabbit says, I don't recall why the super chat, but it must be right. I just don't recall. So we're just super chatting. Thanks so much, Iron Rabbit. Use the I don't recall emojis, you guys. There's a couple new emojis in there that I put up while we were live today. So there's an Uno reverse card. So that's good when someone flips the question back on the person asking the question. We got a little young Doug in there, Doug Weinstein. And then there's one of Kenneth Copeland, but there are a lot of faces of Kenneth Copeland. We could probably make a whole row of Copeland facial expression emojis. So I'll have to work on that. Thank you so much, Iron Rabbit. Good to see you. As Satchel says, I can see where the legal community will call this the Woody defense. Just a persistent, I don't recall, and then I'm innocent of everything. Thank you so much. Good to see you. And then Annie Bailey Brown, you're right. Hilton seems like the defense's secret weapon. So thank you so much for your super chat. Mason Martin says Threat and Woody probably killed Nut. And we had done a poll yesterday, and I still think that looked like that for sure. I think there's enough for a jury to think that a different culprit besides the people charged here could be responsible for the murder of Donovan Thomas. I definitely agree, Mason Martin. And again, maybe I'll change my mind. But I think the state still has the uphill battle on that incident. At least their theory of what happened. Marlena Mack, good to see you. Are we still dealing with nosebleed or lunch? I don't know. Because, I can imagine Judge Whitaker being like, guys, it's 12, so we're just going to take a lunch. Let me zoom out. Sometimes a long crime chat will know. Oh my God, the whole chat is asking about the Melnick suspension thing again.
Yeah. Melnick says, listen. And Melnick knew this. This is the messed up thing. Melnick knew this, and he still didn't do it. Melnick calls the client in and says, listen, lady, I'll be honest with you. Your case fell through the cracks. I've been busy. This is why I call you at 7 p.m. at night, 8 p.m. at night. You ever wonder why I call you so late? It's because I'm so busy. And I'll be honest with you. I'm busy because I'm a good attorney, but I'm not a perfect attorney. And your case fell through the cracks. Did it fall through the cracks? No. But that's what you tell the client. Your case fell through the cracks. And because it fell through the cracks, you are ordered to pay $3,600. The attorney the client starts flipping shit because she ain't got $3,600. And you let the client get all off her chest. I ain't got it. This is your fault. You say, you know what? You're right. You paid me $3,500 to handle your case. And I did all of the work. And now, because your case fell through the cracks, you have to pay $3,600. So what I am going to do is pay the $3,600 for you. It ain't my kid, but I'm going to pay it for you. And I'm also going to refund you your $3,500. So you got all of this legal work for free.
That would have been nice.
It's not nice. You're not doing it to be nice.
Yeah.
Right? You're doing it to protect your reputation and to protect your license with the bar. So if you refund the lady her $3,500 and you pay the $3,600 refund, she got free work. She's to the good. She got her case handled for free, not in the way that she would have wanted it, but she got her case handled for free. What did Melnick do? He did the opposite. He didn't want to refund her the $3,500, let's assume it for the case, and he didn't want to refund her the $3,600. How do I know? Let me show you how I know. I know this because she had to file a bar complaint. First of all, she went to an attorney, and the attorney called Melnick. You know what you do when you're an attorney and you get a call from another attorney, say, hey, we're thinking about a bar complaint. Here's the money. How much you need? Just write the check. Mm-hmm. Just write the check. How much does she want? She needs $7,000, leave.
Yeah. It didn't have to go that far. He
It didn't.
could have stopped it right there.
Yes, because the attorney, and I've made so many of these phone calls to these attorneys. Hey man, your client came and she's saying some bad shit, but that's okay. Here's what we want. We want two things, and I'll take it from here. First of all, I need the file. I need the file. She didn't have all of her paperwork. Please send me the file, or I'll send if the attorney's in town, I'll send my runner to go pick up the file. Can you have the file ready by 2:00? Yeah, I'll have the file ready by 2:00. Good. All right, thank you, Lee. Oh, there's one other thing. My client paid you $7,500. She gonna need that back.
Mm.
All right, Lee, she gonna need about half of it back. What's half of 75? Actually, pimp, she gonna need it all back. She gonna need it all back. And it's her like, well, come on, lead. I did all this work. This case being, I know. We don't want to have to go to the bar. All right, lead. All right, here's your $7,500. Come pick up the file by 2:00. What did Melnick do? Melnick didn't give any money back until the attorney called Melnick, and Melnick didn't pay, and the client filed a bar complaint. Only after, y'all see this word, after the client filed a bar complaint, then Melnick paid $3,500. What's the problem with this? The problem is that the client was ordered to pay $3,600.
You short a little bit there.
You're short a little bit there. And not only was the client ordered to pay $3,600, but Melnick got paid for the client's case. Let's assume the client paid $3,000 for the case.
Yeah.
So
she also had to pay the other guy's attorney's fees.
Yes. So Melnick didn't even pay the half. What is that? It's what I've been telling y'all since day one. It's a gangster. I just did a stream. I just made it members only yesterday. I did a stream for 4 hours 2 days ago. I was answering y'all's questions about divorce and all this stuff. The theme of that was attorneys are gangsters. And you have to be an advocate for yourself. You cannot put your case in these attorneys' hands and just set it and forget it. You will get taken advantage of. You will get stolen from. Sometimes. There are attorneys who you can set it and forget it. I would hope it's the majority of attorneys. I'm going to say 55%, maybe 60%. But there are 40%. What are attorneys, guys? Anybody know what attorneys are? They're human beings. And human beings, they're strangers apart from that. And if you overpay a stranger, are you going to get that money back?
Yeah.
Maybe.
He's overextending himself,
But maybe not.
Mm-hmm.
Yeah, so I've still got my eye on the law and crime stuff, guys. They are not back yet. I don't know what happened with that emergency that they had in that courtroom.
Oh, he said something about a nosebleed, like one of the jurors is having a nosebleed.
Oh, one of the jurors having a nosebleed? Okay.
Yeah.
All right, so we're gonna keep going, but I'm dropping like inside knowledge about these attorneys, guys. Y'all don't really know about this. Y'all think y'all could just pay an attorney $10,000 and just sit back. And then when they fuck up your case, you can't even get the $10,000 back, and they're gonna try to shortchange you on the other repercussions that the case was messed up. All right, let's keep it going. So that was one thing. This client maybe was out, let's say $7,000, but the $3,600 plus whatever she paid for the case, Melnick only paid her $3,500.
Wow.
All right.
And do you think with attorneys that do multiple practice areas, because now he's doing criminal apparently, and he was handling Woody's case like 2 years ago, so he was doing criminal and it looks like family law at the same time.
That's very common.
Okay.
That's very, very, very common. Most attorneys handle at least multiple things, especially as you get older, because you just know so much.
Gotcha.
You just know so much. So that's very, very common.
Mm-hmm.
In fact, when I started out, what was my practice? Was it criminal law? Was it family law? Was it tort law? No, my practice area was door law. What is door law? Anything that walks through the door. I got you, baby. What you need? A slip and fall? Oh, yeah. Go inside this retainer. Oh, a divorce? Oh, you aggravated us? Yeah. Got it. What happened to you? I got you. Anything that walked through the door.
Yeah.
Right. It's a door law. All right. That's how you got to start out, man. That's how you got to do it. All right, AV, you want to pick it up right here?
Yeah, let's go to the special master's report. So this is the arbiter that heard this. After the evidentiary hearing and consideration of the parties' briefs, the special master concluded that Melnick willfully violated rules 1.3 and 1.4, so diligence and communication, and that his conduct harmed his clients. The maximum sanction for rule 1.3 for diligence is disbarment, and the maximum sanction for 1.4 communications is public reprimand. In addressing the appropriate level of discipline, the special master considered the facts and circumstances of the violations. This court's precedent in similar disciplinary cases, mitigating and aggravating factors, and the ABA standards for imposing lawyer sanctions. The ABA, guys, is the American Bar Association. Looks like there's a case cited from 1996. The special master concluded that 4 aggravating circumstances applied. 1, prior disciplinary offenses. See ABA standard 922. A includes a pattern of misconduct. Don't have B there. C is a substantial experience in the practice of law. And I, a refusal to acknowledge the wrongful nature of his conduct. See ABA standard 922.
All right, just to jump in, big shout out to Legally Shay. Legally Shay knows about that door law. I mean, what she's calling it is really what it's called. You're just a general practitioner. It's kind of like if you're a doctor and you're just kind of like a family practitioner.
Mm-hmm.
You know, a broken bone, come on in. A splinter, come on in. A burn, come on in. Right? Domestic violence, come on in. Just come on in. We'll figure out something. And that there are a ton of general practitioners, especially if you're a solo. If you're in big law or something like that, maybe you just have one, specific field. But if you're going to be out on your own, especially, you need to widen your net. So shout out to Legally Shay. Shout out to all the attorneys in the chat, man. She knows all about it.
Shay's amazing. She's up here in Massachusetts. She gifted a ton of memberships on my side 2-3 days ago. And
do you know who she is? Well, shout out to Legally Shay.
She's amazing. She's and even in her comments, she's very thoughtful, does the research, explains things. She's newer to our community, but Shay's awesome.
Shout out to Shay. I've never seen her. So shout out to Legally Shay. What did she say? Whatever comes in. She's exactly right. She's exactly right. You got to get this money. Okay.
Exactly.
All right. So let's keep it going. Right here.
Yeah, the special master also determined that 3 mitigating factors applied. First, she considered the existence of personal and emotional problems that Melnick said he suffered. Although she gave this factor only some weight, noting that some of the circumstances Melnick relied upon as mitigating did not occur during the time frame in which he was representing the client, and that Melnick, who had been given an opportunity to submit documents after the hearing, did not submit any documents supporting his testimony about having participated in counseling.
All right, so this looks right here. First of all, the court of the tribunal gave Melnick a chance to explain.
Mm-hmm.
Say, Melnick, why are you letting these cases fall through the cracks? Melnick, I got personal problems at home. I got this mental stuff. The court's like, okay, have you done anything to address it? Yeah, I've been going to all this counseling. Okay, I'm gonna find that's a mitigating factor. It's not an excuse, but we're all human. So the tribunal says, okay, you've been doing all this counseling. Just send us the receipts. Melnick's like, okay. No receipts. No receipts. He says there was counseling. No receipts, no proof of the counseling. All right. No documents supporting his testimony about having participated in the counseling. All right, but let's keep it going. Second.
Second, Melnick made a timely good faith effort to make restitution or rectify consequences. That this is standard 9.32, as he eventually paid his client $3,500. Finally,
And I disagree with this.
Yeah.
And, the tribunal knows more than me. But Melnick made a timely, good faith effort to make restitution. How do you make restitution of paying $3,500 when your client was out $3,600?
Right. It's less, first of all.
It's less, first of all, exactly. And how is it timely
Right.
if you knew months and months before about the $3,600, but you waited to pay it until after a bar complaint was filed? So I don't know how that's timely. If you already know that a bar complaint is filed against you, but okay, let's keep going.
And real quick, it looks like a shout out to Derry in the chat. It looks like Law and Crime pinned something saying that they are on lunch until 1 p.m.
Oh, thank you. Thank you so much. So Law and Crime is on lunch until 1 p.m. It is 2:19. So that's good because that gives us a few minutes to go over this. All right.
Yeah. The special master did not address Melnick's argument that she consider as mitigating factors that he lacked a selfish or dishonest motive, that he was cooperative with the disciplinary authorities, and that there was a delay in the proceedings that was not caused by him, given the formal complaint was filed 2 years after the grievance was filed and was based on events that occurred over 5 years ago, and that he was remorseful.
Jesus. So Melnick was just trying to hang on. All right, let's read this. This might help Melnick. You got to read the footnote sometimes.
Yeah.
Melnick testified that he had marital difficulty for many years. What did I just tell you? What did I get, guys? Good luck first of all, good luck being married in the first place. All right. We already know that just a regular marriage is a roll. Is a roll of the dice. It's a crapshoot 50-50. And then you're an attorney being married, so that you already know that's a little difficult. So he said, Melnick testified, hey man, forgive me. I've got marital difficulties, cared for both his parents through long-term serious illnesses, which is a huge thing.
Yeah.
Had ongoing health issues of his own, which is another huge thing, and had participated in counseling. At the conclusion of the evidentiary hearing, the special master invited Melnick to submit to her with a copy to the state bar any documents that would support this aspect of his testimony. And that's what he did not submit. He didn't submit any documents regarding that.
Yeah. And like with all of that in that footnote, that is grounds to hire a paralegal at least, or a secretary to help you.
Yeah, we should get some help.
Addressing the sanction that was warranted, the special master determined that a public reprimand was not appropriate. See ABA standard 4.43. It says a reprimand is appropriate for violations of rules that occurred based on negligence rather than knowing behavior. And that Melnick's prior disciplinary history subjected him to enhanced discipline. See Bar Rule 4103. A finding of a third or subsequent disciplinary infraction under these rules shall, in and itself, constitute discretionary grounds for suspension or disbarment.
And this is another thing, guys. Y'all ask me so many times. Y'all know I do these consultations right on my website, and y'all will call me up or book a call or do a Zoom call or something, or sometimes y'all want a telephonic. Y'all say, hey, Lee, my attorney's doing this. What do you think? I'm not really feeling it. My attorney's doing that. And sometimes y'all have gotten in such a bad way with your attorneys, or your attorneys are so bad that you really do need another attorney. What's the problem? The problem is you picked a bad attorney. Now, this can happen to anybody. And you guys always ask me, how can I pick a good attorney? How can I pick the best attorney? What's the guarantee that I don't get an attorney that's going to do the things like Melnick? I'm not going to say, you don't want an attorney who's going to take your money.
Yeah.
Guys, the best way to get a great attorney, number one, is through a referral. First of all, there's no guarantees. There's no guarantees. But if you've got somebody who is raving and raving about their attorney, that he's so great, that's a great sign. But whatever attorney that you get, what you want to do is go to the state bar. Go to the state bar's website, whatever state you're in, and just look your attorney up and see if there has been any previous disciplinary actions against your attorney. Now, I know attorneys who are bad attorneys and there's no previous disciplinary action. So it's not a guarantee. There's never a guarantee. But apparently, this is Melnick's. Melnick has had multiple disciplinary actions. So you might just want to check. And it's not a guarantee because, again, they might not show it. But sometimes they do show it. And if they do show it, maybe you could pick another attorney.
Yeah,
all right.
That's great advice, Lee. Thanks for sharing that.
Mm-hmm.
Instead, she recommended that Melnick be suspended for a period between 90 days and 6 months, consistent with prior cases, such as in the matter of Sakas. That's a 2017 case.
Yeah, you don't have to read all these other cases.
2010, 2008.
Jesus, a lot of cases.
2006, 2005.
All right, so they recommended 3 months to 6 months suspension. All right. The review board's report. You want to pick it up here?
Yes. Melnick filed a motion asking the review board to review the special master's report. See rules 214, 215, 216. He contended that he did not violate rule 1.3 and that in any event, a public reprimand was more appropriate. The review board concluded that Melnick did indeed violate rules 1.3 and 1.4, so diligence and communication. He tried to say that he did not violate diligence. Adopting the special master's factual findings and conclusions of law in all respects except with regard to the consideration of Melnick's prior disciplinary history as an aggravating factor. The review board stated that it discussed at length the prior disciplinary history and believed that the more than 15-year period since any prior disciplinary history should not only mitigate, but also should outweigh the extent that this history is considered an aggravating factor. It also disagreed with the recommended discipline and recommended that Melnick receive a public reprimand, which it concluded was consistent with prior cases such as Pagano in 2006.
Yeah, just prior cases. Just start right here.
The review board also recommended that Melnick complete a law practice management assessment.
All right. I'm looking at Melnick's what do I want to call it? Melnick's information on the Georgia State Bar. And I don't want to show it just because there's a phone number here and I'm not sure if that's his office number or it could be his cell phone number. I don't want to dox him. But it's showing his status as suspended, but he's not suspended for this. He is suspended because he did not complete his he didn't complete his CLE requirements. What are CLE requirements? CLE requirements, exactly. See, he hasn't complied with his continuing legal education hours. All of us attorneys have to get a certain amount of hours each year, and he has not gotten those hours. But just like I said, guys, his public discipline, what does it say? It says right now, it says none on record. None on record, even though he has had other disciplinary actions in the past. And, maybe the court, maybe this webpage, it'll take, a day or two to refresh to get this one on. But it's not a guarantee that you go and pay an attorney $3,500 or $5,000 or $7,500 or $10,000, and your attorney could have a ton of public or let's say private reprimands or other disciplinary actions. but at least you need to check.
Yeah,
right?
I think you're right too, because it's like, people can always either do due diligence. Like if you Google him now, the 5 stars are not fiving. Let's just say that.
The 5 stars are not 5.
5 stars are not fiving. And
Jesus.
even with CLEs, you're required to do that.
Yes. Yeah, like the CLE thing is crazy. Like just
Yeah.
go ahead and
Yeah. Oh, by
get
the way, I think chat is almost at 7K likes.
I wasn't even looking at the light. Let me pull up the chat. Oh yes, y'all are here. Well, let me let y'all in. Thank you so much. Thank y'all for getting my likes right. And AV, you remember there was like 2 or 3 weeks, maybe even a month, where y'all would get the likes right the whole time. Y'all were never locked out.
Mm-hmm.
Never locked out. I don't know what it is now. Y'all are backsliding and half stepping. But
they were leaving me comments like, can you tell Lee to let us in? That came to my channel. IG messages like, y'all on some BS. Let us in.
All right, come on in, guys. Come on in. AV is up north. Your boy and me, I am in Atlanta. Down here with Melnick. Down here with Whitaker. Down here with Woody. Down here in Atlanta. When y'all come in, let us know where you are from. What city are you coming in from? Come on in, family. Y'all are family. Thank you for getting my likes right eventually. Only took y'all asses 3 hours, okay? But come on in and let me know where y'all are from. Now, let me slow down the chat a little. Kentucky. We got London in the house, North Carolina, Detroit, Baltimore. All right, H-Town. Shout out to Scarface. Got Houston, Austin, Texas. All right, y'all are coming in. Y'all are coming in. Barbados.
Look at that.
Shout out to Fresh and Fit. Got Valdosta. Nicaragua. No manches. Okay. We got La Raza. We got the Hispanics up in here. Got London, Ohio. Shout out to Bone Thugs and Harmony. Arkansas. He represented Woody. Represented Woody in this, and I'm just catching this. We got legally. I know I got a lot of supers to get through, but me and AV, and I'm so caught up in running this show that we're gonna get to the supers and stuff. But now I was letting you guys in. Shout out to South Africa. All right. Oh, Tuscaloosa. All right. I was letting y'all in and I saw this. So big shout out to Legally Shay. Somebody write Shay in the chat. Blessing y'all 20 members, 20 memberships she has given. So tomorrow, when y'all don't have my likes looking right, there are 20 of y'all that will not be locked out. Shay has blessed y'all for 30 days. Y'all will be able to come in even as the other chat is playing in my face with the likes. So if you received one of Shay's, Legally Shay's memberships, please tell her thank you. And don't just say thank you. I don't know where Shay is from, but your boy is down here in Atlanta. I'm from Georgia. I'm from the South. And in the South, we got home training. It's called Southern Hospitality. Tell her thank you. And those don't say, oh, well, thank you. No, tell her thank you, Shay. Put a name on it. What did Judge Glanville teach us? That the names must be named. Judge Glanville wanted the name of the mole. Do you remember?
Yeah.
He wanted
Who told you?
Who told you? He threw Brian Steele in jail. Because he wanted that name. And then it turned out, according to Kayla, who was the mole, it was a
deputy.
The deputy.
Mm-hmm.
And word on the street is that the deputy has now been demoted. Did y'all hear that? I think
that's what Glanville wanted.
I think infamous Sylvia said once they found out who that deputy was, they demoted that deputy. What was his name? It wasn't Long, was it? What was
what was the other one? Brown.
Mm-hmm. Brown. So they demoted that deputy from being the mole, from violating the sacrosanct nature of Glanville's chambers. That's what Glanville said. It was sacrosanct. He said his office was sacrosanct. Brian Steele put in a motion. Do you know what sacrosanct means? He put the definition. He said it was holy. Sacrosanct means holy.
That was funny.
Who in here believes that Judge Glanville's office is holy? Holy Judge Glanville. I've been in Judge Glanville's chamber. I'll be honest, it's a nice office. He's the chief judge. It's a nice office. It's really, it might be one of the best. It might be the best judge's office I've ever been in. It's big, pause, and it has all of his awards and certifications. You know, the flag. He's in the military, a general, 35 years in the Army, something like that. It's a big. I've been in some judges' offices that were damn near closets. They were tight. So it's a big office, but I do not know if I would call it holy. I don't know if I would do that. All right, but yeah. So let's keep going. All right, so let's pull this right back up here. And before we get into it, AV, do you have any cash apps that you want to shout out?
Yes, I haven't read a single. Well, I think I got one. We did get Full Drink and Half Thinking. Thank you so much, brother. Really, really appreciate you.
Yes.
Shout out to Brooks, who sent me 50. Kevin Brooks, it was good to see your name here. Thank you so much, Kevin. Always nice to see you on this side. Why So Serious sent me $1 and says, tell TLA to create custom I don't recall emojis.
Okay, I don't know how to do that, but I'm old, guys. I'm 47, so but yeah, I should look into that.
Thanks for the suggestion. Shout out to Jeremy, who sends me $5. Says, would he want them to know he is shooter real bad? Yes, his testimony was serious this morning. Shout out to Life of Coop, who sends me $20 and says, keep your head up. This is a shit show. Indeed. Thank you so much, sis. Shout out to Maricela, slinging them cars. Hope you're doing well, Maricela.
Yes.
Yeah, she sends $15. She says, for a badass woman, love the white nails, by the way. Thank you. I mean, I just got them done and they chipped. And you guys know how I feel about white nails because of Diddy.
Shout out to Diddy.
Ooh, scrambling and scraping. Shout out to Simi, who sends $1, says McDonald's declined to release the video footage. Yeah, they're not going to release it. But this is when we were talking about what the prosecution has. So it's likely that Simone and them have corroborating pieces of evidence. I'm trying to get a forensic expert on my channel this Friday to talk about some of that data, that cell phone data. So that's going to be fun.
That'd be awesome.
Yeah, it certainly will be. Let's see. I want to shout out Danielle. We had this Melnick document, but she's always on top of it. She sends it to me right away. She sent me an email. Thank you so much, Danielle. Carlos sends $1 and he says, blame the bilinguals for everything. Sorry, lead.
Blame the bilinguals.
Shout out to Drew Beats, sends me $5. He says, AV, are those freak off nails? Yes, you caught the white nail polish. You did. I was on protest. Like I was not going to pick this color for like a year. But it happened. Shout out to Carlos again with another $1. Thank you so much, Carlos. He comes back with another $1. He says, also tell lead that the engineers make an average. I think he ran out of character space. I think it was how much money engineers make, because it says something K, but he didn't give me a number. Thank you, Carlos. And then shout out to Diamond. It's good to see you. She sends me $5. She says, thank you so much for the God's Hue video. Hey, lead, mucho gusto. And Diamond has her own, I was thinking about you this morning, Diamond. She has her own makeup brush line and she sent them to me right before I left Atlanta. And yeah, I made a little promo video for her, posted it to my Instagram, and I used those brushes this morning. So y'all check out Diamond. She is amazing.
That is awesome. Yes, y'all are always raving about how beautiful AV is, and AV is using those diamond brushes. All right, so shout out. And I know I got a lot of super chats. I'm going to keep it going right here, but big shout out to the Little Gaming channel. Shout out Little Gaming channel. What does he say? Little Gaming channel, excellent content creator, excellent high value man, says Woody, shooter and can't remember anything. Kaylor, lawyer being belittled by the judge and showing half her areolas, Melnick going on vacation, leaving his client, then being suspended for 6 months. What a clusterfuck of a group.
This week has just been wild.
Guys, it's like, oh man, and that's why I love, and you guys have no idea, Legally Shay can feel me on this. I love being retired and just being away from the BS. I like to,
Yeah.
shout out to, do y'all remember Juvenile back in, Hot Boys and all that?
Juvenile.
Juvenile was amazing. I remember when I was in high school, Juvenile in Atlanta, they have the top 8 and 8 on the radio. So they play the top 8 songs. Juvenile and the Hot Boys songs, they would be all 8 songs. They would take up every single space. Every single space. But Juvenile had a line in the song said, I'd rather see it on TV than to see it in person. And that is how I feel about this damn kid. I'd rather see it on YouTube and just chill and talk about it on Law and Crime. It feels so good because once you get into it, it's like exactly what Little Gamer Channel is saying.
You remember when the trial first started a few months ago, we were going to go to the courthouse and come back to you guys and report, right? But I think this is so much easier because we're getting information out faster.
100%. 100%. It's fast, so we could pull documents up like this, and go through it. But yeah, the Little Gaming Channel is exactly right in that it's just so much BS going on. So much BS. So I'm happy to see it, but from afar.
Right.
And I'm happy to be involved, but only tangentially. Don't try to give me a briefcase and a pen and an iPad and a laptop. Say, Lee, go run up in there and do a cross examination. No. Why would I want to do that? Right. So shout out to, and does Legally Shay, does she have a YouTube channel? Is she a YouTuber?
No, she's very, very new to our community. I think she found me a few days ago.
Oh, okay. I was gonna invite her up. Hit the link. Let's get some attorneys up in here.
Right.
Keita, I don't know if she's in here. Keita never wants to come up.
Yeah, we've gotten a huge influx of lawyers over the past week. There's been a bunch of new men that are attorneys. Remember Talk That Law started doing his thing.
Talk That Law. Yes. Every time I look, I see attorneys that have, 7 subscribers or 300 subscribers or 1,500 subscribers.
Remember The Legal Good? I haven't seen him in a while either. The Legal Good is
yeah. It's hard to try to practice law and be a YouTuber at the same time because then not only do you practice law, but you got these families, you got kids and a wife, and you got court cases, and you're trying to do law.
We're like creating our little law tube over here.
Yes, and it's like, why? Why are attorneys coming over to law? And not only attorneys, there was a huge video that went viral of a doctor, an MIT trained surgeon who had practiced for years. He quit and he made a video about why he quit and came to YouTube. And that video has millions and millions and millions of views. So many professionals are leaving. So many regular folks are leaving their jobs. So many nurses. So put a 1 in the chat if you are in the healthcare field and you know about all the BS that nurses go through. Nurses are leaving. Everybody is trying to do something different. And why? Well, let me give you a little gander as to why a little bit, guys. I made this video as part of my course that shows how much I make. Now, we talked about how much Judge Glanville makes, $139,000 a year. I pulled that up. I showed you guys how much Judge Whitaker makes. Y'all remember Judge Whitaker? I think I had that pulled up right here. Let me pull that up. It's in open records in Georgia. Judge Whitaker is a state employee. So all you have to do is go to Open Georgia and you can pull her up. Here it is. Paige Reese Whitaker. That's not how I want to do it. Let me pull it up and what am I doing? I want my little pointer thing. Pause. Let's see. Judge Paige Reese Whitaker right here. Y'all see how much does she make? She makes $139,000 for all the BS that she's going to go through. All of the BS in this case, all the corruption that she's apparently taking a part of. Now, she's actually a participant in the corruption by not holding the prosecutor's feet to the fire. Paige Reese Whitaker is making $139,000, and then she gets a little $3,000 stipend for travel. All right, would that be enough for y'all? Now, let's be honest. I think the average American is making 50, 60,000. So, in Georgia, that's pretty good money, if we're going to be honest. But how does that compare to a YouTuber? How does that compare to the lead attorney, right? What does it look like? Well, let's take a look. Let's take a look here. Let me pull it up. Well, how much do I make? Well, I make, bam, there you go, $116,000. Now, is this $116,000 a year? No, it's not $116,000 a year. It's for half of the year. Guys, this is from, I made this when it was about half of the year in June. So this is $116,000. Now, that's not all of the money because I sell a course. I teach you guys how to do this. How much did I make on my course? $154,000. Now, that's for half of the year as well. So you got to times 154,000 times 2 and 116,000 times 2. Then I also got a Rumble contract. Y'all know about Rumble. And so I was making about $57,000 over there. So if you add it all up, guys, for half of the year, it was $327,000. And that's for half. Can somebody do some math? How much is 327,000 times 2? Does anybody know how much that is? 327,000 times 2. Y'all want to know how much do YouTubers make? Ollie, you just sitting at home in your spare bedroom. The door is right there, guys. The kitchen is right out there. That's why I got this bowl of I had the bowl of watermelon. It's empty now. The kitchen is right there. So I'm over here eating my watermelon. Is that racist? I'm over here eating my watermelon at home in the middle of the day, and what it's looking like. It's looking like $327,000 for half of the year. All right. And I teach you guys how to do this. I really am the #1 teacher of live streaming in the United States. All right. There are live streamers who are bigger than me. I don't even have 500,000 subs. But in terms of Playboy, I think I'm #4 in the nation yesterday. #4 in the nation in terms of live streaming. Just yesterday alone, #4 out of all the millions of YouTubers. And the 3 people above me do not teach you how to do what I'm doing. Mm-hmm. I'm the only one that teaches you, the top one. And I've got a course that teaches you how to live stream. And now, is the course $2,000, $2,500? No, even though it's worth that much. And is it, I think it's like $550. And I have a discount code called skills. If you put in skills, because that's what you need to make this type of money, you need some skills. And that's what you're going to learn in the course, guys. $200 off. So it'll cost you $350. All right. Is $350 a lot to make this type of money? Or even if you can't make this type of money, let's just say I'm a natural, I'm good. Even if you make $20,000 a month or even $10,000 a month. Some of y'all, let's be honest, are not making that. The judge is barely making $13,000 a month. This is the #1 course, guys, on teachable.com, a beginner's and an advanced course. And the advanced course really teaches you how to get the money. I got a course bundle where you can buy both the beginners and advanced course for a discounted rate. But guys, it's not even really about the money. It's just about happiness. I am so happy now. You guys will not believe it. Even though I'm going through trials and tribulations like everybody else, the fact that I could be home and just do what I want to do, have the freedom to travel, the freedom to work if I want to. If I don't work, I'm gonna take a break in the latter part of this year. Y'all ain't gonna see me. I'm gonna be dipped out. Maybe I'll come back at the end of the year, maybe next year, who knows? But that's what this YouTube affords me. And some of y'all have kids and a wife and you hate your damn job. What I'm telling you guys is that if you are 35 years or older, you have wisdom, you have experience, and you have knowledge. Just try it. Just try to come to YouTube. There's so many people that are coming over. So many people. Y'all are asking you how do y'all join the course? Let me get the course with the course link with the discount code in the skills. It's $200 off. And guys, the best thing about this is that you will not lose a penny. There is a 14-day money back guarantee, 100% guarantee. You guys do not need to tell me why you didn't like the course, or if you didn't like the course, you can love the course. You can take this course, take it all, email me, say, hey, I want my money back. I will send you 100% of your money back. Why? Because y'all see the money that I'm making. I'm not stressing out over $350. Y'all can have it. Y'all can have it. If you feel like the course was worth $350, then just take it. But if you feel for any reason that it's not, it's a 100% money back guarantee. Just email me. And you guys see, I don't have any problems in giving refunds because I'm in the happiest point of my life. The only regret that I have is that I found this happiness at 44 years old. And it would have been so much better to find it at 38 or 32 or 27. But just try it, guys. If you do not like your job, if you're stressed out, if you're worried about money, this inflation, just try it. Let me tell you something. I haven't looked at prices in a grocery store in years, and I'm not rich. Y'all see, if you multiply this number by 2, you're not rich. You're just not. All right. But just the freedom to go into a grocery store and get whatever I want and not look at Nan price. Nan, I'm from Atlanta, from the South. That's nice. People are talking about inflation. I go to the gas station. I don't look, just here. Just however much it is, that's how much it is. Little shit just gives you so much more freedom to be able to go to a restaurant, not care what the damn prices are. Right? Me and AV were out there at Vegas for a day of meetup. Took her to dinner. It was $700. Who cares?
It was great.
It was a great dinner.
It was so good.
It was good. It was good. $700. Who cares? Right? Because what is $700 when you're making this times 2? It's not that you're rich. It's just that you have a freedom. Guys, this course, some of these people are selling courses. They're 2 hours long or 4 hours long. How long is my course? It's 18 hours long, guys. 18 hours. I put the whole thing in your mouth. I teach you everything you need to know. And that's just the beginner's course. The advanced course is when we start talking about the money. And it's ridiculous. It's ridiculous how much money there is. So shout out to Judge Whitaker making her $140,000. But just like the Little Gaming channel said, man, it's so much BS. I love to be an attorney. One of the best things that ever happened to me in my life was retiring and just getting out of the BS, because it's so much corruption that you have to deal with. So many things that go wrong. So many judges that don't give a damn. So many opposing clients that are trying to rob you, trying to rob their clients, not doing a good job, just gunking up the whole system. Yeah. And if I'm being honest, this is what we're reading right here. We are reading about an attorney who kind of went gangster a little bit. And I don't want any smoke with Melnick. I don't know this man. And I don't know what went on. But I know he's been suspended from practicing law 6 months. Mm-hmm. Let me tell him Melnick needs to buy my course and come over here.
Right. He was doing YouTube interviews like 2 weeks ago. So
was he really?
Yeah, you know how like all those attorneys, some of the defense team, like Melnick was doing interviews with Kayla, with other people as well.
Mm-hmm. You know. They all need to come over. They all need to come over. All right. So let us keep it going here. We are looking at Melnick's suspension. He has been suspended from the practice of law for 6 months starting today. He is not allowed to practice law. How do you, if you're a carpenter and you've been a carpenter for 25 years, 30 years, and you hurt your hand, you break your hand, it's gonna take 6 months. How do you make a living? That's the problem. Ask Legally Shay. Legally Shay, if you're in the chat, what would you do if you couldn't practice law for 6 months? How would you keep the money coming in? How would you keep it in? How would you feed your family? I just don't. It's such a bad result. Now it's way better than getting disbarred.
Yeah.
But like any of you in the chat, put what you would do if you starting today could not work for 6 months. And no vacation time. Oh, well, my job's gonna pay me vacation or Cobra or anything like that. No, nothing.
Yeah.
What are you gonna do for 6 months?
Oh, and Lee, before I forget, by the way, Michael Love asked me yesterday that there is a gifting option for your course, right? How do people find that?
Yes. If you, Juliana said she would cry. She said she would cry. That's exactly right. If you would like to, and I gifted my own course to Woody. I gifted him the beginning and advanced course. Shout out to Woody, man. Miss Hall said she would go straight to OnlyFans. All right, start showing them feet. Yes, if you want to gift the course, there is a little checkbox, and you can put the checkbox and put the email address of the person that you want to give it to, and the course will go straight to them. Or you can buy it yourself and then just give them the password and email and just do it like that, right? If there's somebody who you feel like could be a YouTuber, maybe your son, maybe your daughter, your cousin, your nephew, gift them the course, $350. It could be the best gift that they receive in their entire life. It's the gift that gives on giving, because why? When you purchase the course, do you have it for 30 days, 60 days? This suspension right here is 6 months. Do you have the course for 6 months? No, you have it for a lifetime. You have it for a lifetime. So shout out to Mama. Mama says, I wish I could afford the course. Somebody could gift you the course, baby. You ain't got to go to OnlyFans, all right? Y'all are going straight to OnlyFans. Y'all ain't got to do it. All right. Ed Lil says Woody is live right now. Is Woody live?
Yeah, I checked. He is live. He's at the courthouse. He's on his second account. Guys, Woody has 2 accounts. He has Woody versus Woody, which I think we helped grow because when he first came out with that, he had, well, I think like something like 23,000 followers. Now he's at 200,000.
Wow.
So he tends to not post on that account as much. The other account that I sent you yesterday, Reed, is where he's been going live from. Apparently, he's making fun of Hilton. He said Seti Nash is his new lawyer. There's a bunch of things happening.
Seti Nash is his new lawyer?
I don't think Seti Nash is an attorney.
No, I think it was just a joke. I think they had that thing. You remember, guys, when they had that fake beef?
Yeah.
Did anybody see when they had that fake beef? So shout out to Woody and Seti Nash. Shout out to Tailor Made Studio, sends me $5, says, I wonder what's going through Thug's mind. Absolutely. And shout out to DeMarcus. DeMarcus says, I'm a Twitch creator, Gilgamesh 2007, and he says that you are gold. So thank you so much. I appreciate that. So really appreciate that, guys. AV, do you have any super chats you want to read before we get right back into the suspension?
Yeah, and we have a few minutes before court's back in session, so that's good too. Shout out to Amy, who sends me $20. Thank you so much, Amy. She says, have a beautiful day. Thank you so much, Amy. That is very sweet of you. Shout out to King of AFK, sends $1. He says, Jack Marie Maj Gang. Oh, you know about these. You know about these $1,000 glasses that Kevin Samuels made me buy.
Yes.
You already know. Awesome. Yeah, no, these are a great glasses brand. Guys, before Kevin Samuels passed, I had an opportunity to do a few sessions with him. I did a style session with him, and he picked these based off of the shape of my face. And it's this amazing brand that these are the same, not the same shape, but these are the same brand of glasses that if you look at Kevin's old school videos, he's wearing these, and you could tell by the little arrow in the corner. So I'm happy that other people wear them. Shout out to Orlando, who sends me $5, says, Woody exposed Brady. I told you in back room. That's a good observation, Orlando. When he was this is when Woody was talking to the prosecutor and said, I told you in the back room about
Mm.
some of this stuff. So thank you, Orlando. That's a great observation. And then lastly, shout out to Dub Right Side with the $10. He says, keep up the great work. Thank you so much, Dub. Always a brother to the channel and active in the chat.
100%. Shout out to Eliv, says much admiration lead. Been watching since the KS days. Yes. Shout out to KS. KS also had me buy a pair. No. KS told me the store that he likes to get glasses from. What is it? Jacques Marie Mange?
Yeah.
The store right down the street in Lenox Mall. So I walked in there and I picked me out a pair and I walked up to the register. They were like, yeah, it's about $1,000. I was at what?
Yeah.
My previous glasses from LensCrafters, the bitches were $123. I thought that was expensive. Yeah, listen, when you go from $123 to $1,000, but those glasses are so much better. Guys, sometimes you can't pay for a brand and you're just overpaying. But if I put my old glasses next to my new glasses, it's a world.
It really is. And y'all will love this. I used to have some Tiffany glasses with like the turquoise rim. Kevin was like, well, those look a little whimsical. And he's like, those look, I was like, they're Tiffany. He's like, yeah, we're upgrading. Let's get you some 24K gold on the side. Like,
exactly. Wow. Exactly. Me and Kevin, I went to Tom Ford with Kevin, and MTR was there, and we were up in there. And Kevin was y'all know I'm an attorney, right? Well, Kevin by trade was a stylist, so he loved Tom Ford. He was like, Lee, you should get these and get these and get these. And he picked me out a pair of shoes, and it was a sweater and a jacket. So I was like, all right, I'll go on and get it, Tom Ford, whatever. I ain't gonna be a wet blanket, you know. I'm a team player. So I get the shoes, the sweater, and the jacket. Walk up to the register. She rang that shit up. Why it came to $15,000?
Have you spending that money, boy?
$15,000. I looked straight at Kevin and I was like, all right. And this was in New York. So they were like, they'll ship it to you so that you don't have to take it on the plane because you might not have enough room and all this. So I was like, fine. Come back to Atlanta. They ship the clothes to me. I get it in the morning. Where am I in the afternoon? I am at Tom Ford down here in Atlanta in the afternoon, returning all of it. Returned all of it. Give me all of my $15,000. What the fuck wrong with you? $15,000.
You lucky he ain't see you. He was always in that Tom Ford. Like once
always.
He would have been like, Lee.
I need my money back. And I need the taxes, the chip in the head. I want all $15,000 back. The hell wrong with you? I took it all back. Kevin was like, you like that jacket? Oh, yeah, I like it. I like it in Tom Ford. Get this shit out of it never even made it to my closet, guys. Them clothes never made it to my closet. Them clothes made it straight to my garage and to my truck, and I went right back to the mall. Shit, like, Kevin will have you out here broke. Somebody put KS in the chat, man. Oh, I miss him so much.
Me too. I miss the funny little moments, the little jabs he would do with people. You know, his bigger monitor to read the super chats.
Yeah, man. You want to talk about a mentor? Oh my God! I know a lot of people have controversial views. Shout out to all the women. I get it. But if you just knew him as a man, like we would talk on the phone all the time. We never talked about his content. Never, not one time. He would just break down YouTube, the game for me, because I just didn't understand so much about what was going on. That's why these courses are so great, because they can just speed run you through so many experiences. But yeah, shout out to KS, man. Oh my God, you're exactly right. Truly, truly missed.
Yeah.
All right, so the judge said that we are coming back at 1 o'clock. Guys, I am right down the street. It is 1:02. And so we are still waiting. I've got my eye on
You
the.
mind if I get 2 more, Lee?
Absolutely, jump on in.
Shout out to the Little Gaming Channel who sends me $50. Thank
Yes, a
you,
little.
TLGC. He says, you are amazing. Honestly, you are. You have been supporting both of us for 2.5 years. Yesterday, you were in an earthquake, still moderating
He was
on a
working.
19th floor.
Yeah.
So you really are just a huge pillar of this community, and you mean so much to the both of us. So thank you so much, Little Gaming Channel. I want to shout out Michael Love, who sends me $100.
Wow.
Thank you, Michael. He says dinner tonight is going to be lamb, mashed potatoes, and asparagus.
I like that lamb. Okay.
Lamb reminds me of Fogo. I got an email this morning for a coupon at Fogo. I was like, oh, Miss Fogo.
Those fuckers ain't sent me an email since with a coupon since COVID.
Listen, leave me coupon clipping, okay? He be clipping them coupons. He be like, hold on, I have a discount.
Okay, I need a fucking discount. Fogo, where we at? All right, they are back. They are back in session, guys. Let us pull it back up. Let me get them. No TiVo, but that's okay. Let me pull it back up. We are in for the afternoon session.
And can y'all make sure Mr. Copeland's on the way in? I did nudge the temperature up a little bit. It's a little cold even for me right now. Right. Yeah. Thank you. All right, go ahead, Ms. Tiller. Y'all be seated.
May I speak, Young? I was told that Mr. Melnick been suspended, and I don't want to speak without my attorney.
All right. Let me excuse y'all back again. All right, give us just a second. Yeah, that was brought to our attention fairly recently as well. The thing is, he's going to be suspended for 6 months from practicing. It doesn't have anything to do with this case, but do you have another attorney that you want to engage, or would you like for me to find an attorney, a volunteer, basically?
I would like for you to find one.
All right. Well, I had already, actually, the public defender's office had been in contact with me to try to find somebody without a conflict. And they have found somebody named Charles Engelberger. So let me try to get in touch with him and see if he can get down here and consult with you. Okay.
Okay.
All right. So if you want to just step out for now, and I'll take a recess and see what I can get done. All right.
Jeffrey Williamson in the back of the restroom.
I'll tell Mr. Copeland this in a minute, but the attorney is happy to help, but not available until the morning. So I'm going to pass along his contact information, Mr. Copeland, and they can plan to be here in the morning. Question for the state. In the meantime, do you have any witnesses that you could get here that are, you know, like hour-long witnesses whose place in the story does not really matter that much? Like, I think you had some people listed as records custodians and things like that. Any chance we could fill the day with something useful while we've got the jury here?
The two witnesses that we did have on deck to come next were similarly situated. They were Mr. Slade, who's attorney, left town yesterday afternoon, and Mr. Zachary, who said that he is in North Carolina.
Right. So what I'm asking is there a chance you can take some witnesses out of order who aren't integral to the progression of the story that you're telling, but whose testimony you need to get for, you know, whatever reason? Like, you've got some phone record custodians, which I don't know why y'all can't agree to that coming in anyway without a witness, but people like that.
So, Your Honor, the records custodian, for the records that they have to bring in, we do not have business record certs. And so
Okay.
in prior discussion, I believe that the defense were going to object to those records without having the custodian. Those custodians are out of town, Your Honor. And so we would need time in order to.
All right. So it sounds like then that we're just going to have to release the jury for the day and pick back up in the morning with testimony, which doesn't mean y'all are all getting released. Maybe we can get some non-jury things done for the afternoon. But let's get Mr. Copeland in here. I'll give him this contact information. Then we'll get the jury in. I'll release them. Come on. All right, Mr. Copeland, during the break, I was able to speak with Mr. Engelberger, and he is happy to represent you. I've got his name and his phone number written down on this sheet of paper, which I'm going to provide to you, and you can call and speak with him this afternoon. And he is available beginning at 8:45 in the morning. So what we'll do is plan to pick up there tomorrow with you and with him available for you. And in the meantime, between now and then, you go ahead and give him a call and y'all can talk about whatever you need to talk with him about, okay?
Mhm.
All right, so we'll see you at 8:45 tomorrow.
You can give me enough time to talk with him?
Yeah, you can talk with him for the next,
Oh, it's not today?
yeah,
Oh, so he
yeah,
available
yeah,
now?
he's available today. He'll be waiting for your call.
I'm not gonna have any problem with him, is it?
I mean, I don't know why you should.
Okay,
All right,
you take care.
see you in the morning.
Be safe.
Okay, you too.
Hello.
All right, let's get the jury in and I'll excuse them for the day until 9 tomorrow. Hmm? Thank you. Well, ladies and gentlemen, we have had a little bit of a scheduling and procedural hiccup, I guess. So I am going to need to release y'all for the day and have you come back at 9 in the morning to pick back up. We're going to stay and get some other work done, but I'm going to release y'all. I'm going to remind y'all that you are to only decide. We all good? Okay. Decide this case based upon the evidence that you hear in this courtroom. So do not try to find out any information from any source outside the confines of this courtroom. Do not refer to any kind of reference, either old school or online, to try to get information about legal terms, people, places, events, anything like that. Do not talk to anybody about this case. Don't let anybody talk to you about the case. And we will see you all in the morning. Y'all have a good afternoon and evening. And thank you for your time. Sorry, it was a short day today. Y'all are excused. See y'all at 9. Good. Okay, so state, I don't know what tomorrow holds. None of us do about this trial or anything else, but make sure that you've got some other witnesses lined up just in the event that who can get here quickly in the event that, you know, things take some other turn in the morning. Scheduling wise, I think I had mentioned yesterday that next week, I wasn't sure whether it was Monday through Thursday or Monday through Friday. But regardless of what they were told at this point, a juror has a family funeral that they have to travel for on Friday. I've confirmed that. So that'll be a non-jury week in its entirety next week. All right. For us right now, I am hoping that there are some things that we were going to be doing next week that we can just go ahead and tackle today since we all are here anyway. So, well, I think Miss Love, you were, I think, the one that was maybe taking the lead on the PowerPoint issue. And I know you haven't filed a written response yet, but can you just kind of provide us with what your position is on that? And maybe we can we, as in I, can make a decision on that issue.
So Judge, what I said yesterday and what I was asking for was the need for the time to locate within the videos of those proceedings, the period that we addressed the PowerPoint. So I had received just some of the transcript of some of one of the days that we addressed it. And I think that we were addressing the PowerPoint in the context of other objections, maybe that there had been mounted to another witness's testimony. I think it may have been D'Angelo White. So the judge at that point had sort of responded to, it may have been commentary on Mr. Sharp regarding reviewing some evidence the night before. I may have these dates and these times to sort of conflate with one another, but I believe that when he brought up the PowerPoint, we had not yet argued it or talked about it. And my memory is that I said to the court that we weren't intending to introduce that PowerPoint through this, and as I was walking away, I think I said something like through this witness or at this time or today or something qualifying assertion that we weren't intending to introduce.
Okay, but no, basically, if your position is we think that it is admissible, what I'm asking for you to do now is tell me why you believe it's admissible, and I'll just make the decision. Okay, can you do that? Yeah. Oh, yeah. Yes, Mr. Steele attached it to his motion or supplemented motion. So I've looked at it. And I mean, maybe it would be helpful, Mr. Steele, if you just quickly summarize your position as to its inadmissibility.
Your Honor, this is a motion in limine number 49 supplement. It was refiled on August 9th of 2024 on behalf of Mr. Williams. And it was originally filed, and I just, Mr. Adams and I just made it more current.
Right.
But, and that was originally filed on April 17th, 2024. It is my opinion, my memory, and I checked the law and crime video YouTube, that Judge Glanville, and that was a lot of our hearings. I don't know if you watched it, but it was a lot of hectic things, but Judge Glanville excluded it. And the state specifically said they're not going to use it. And to me, I just don't see the admissibility under 401, 2, 3. Because slide 1, it's titled YSL versus Inglewood Family Bloods. That is not the name of this case. I don't know why that would go up in front of the jury.
And I think there are like 80 something or more slides, and I'm not necessarily asking you to go through the details of each slide, just if you can summarize right now.
Okay.
And it may be that we have to get into the slide by slide
Okay. Well,
position, but
it's basically a closing argument. That's really the summary as I would give it. It is something that the state would, over objection, use in their closing argument. And if the court allowed it, maybe that's okay. But for evidence coming in through a supposed gang expert, who I'll be objecting to in addition, he already testified as an expert, and he's the third supposed expert to testify. But there are things, Mr. Williams' home was illegally searched on the July 15, 2015 date. They have slides in there referencing that. They have slides on information that has not come into this trial on supposed investigation and corroboration by law enforcement. I've never seen a corroboration. It's just like a trial by a theory, and that's throughout. And I'm objecting to the entirety of it. And I don't know why any witness, expert or lay person, would be allowed to use this type of demonstrative device to say, let me explain to you the guilt of these people, when specifically even an expert cannot talk about the mens rea or the intention of a party. That's always within the breast of the jury. And this has multiple people, not just Mr. Williams, joining and committing crimes and saying what their intent was by their association. So I hope I've given you a summary, but if you want to go slide by slide, and a lot of information in those slides are not coming into this trial. The state has not called many witnesses that they said they were going to call, like Mr. Lamar, who's a performer known as Rich Homie Quan, Mr. Carter, a performer known as Lil Wayne, Mr. Williams, a producer, performer known as Birdman. They have this information in that slide, and it's just a Confrontation Clause violation.
All right.
Your Honor, the presentation is meant as an aid for the jury to assist them or allow them to see how it is that Detective Dennis reached the conclusions that we expect will testify about in this case. There are instances where he references hearsay, what would be considered hearsay, but which he is allowed to use to form an opinion and to present an opinion. The slides that Mr. Steele references that have to do with matters that have been excluded from this trial, of course, we can see that those would come out and that we would not be attempting to introduce slides that show the inside of Defendant Williams' home as a result of the 2015 search of his home. But there is to exclude the demonstrative that we would be seeking to use through our expert. I don't hear a reason or any basis in law for the just all-out exclusion of information that we believe would be useful to the jury and that Detective Dennis relied on in coming to the conclusion that he did. Much of what is in the PowerPoint does summarize investigations that he conducted. It references persons that he interacted with. It references acts that occurred, investigations that occurred, and again, people that were either self-identifying one way or the other, or that referenced another person as identifying a different way. So we would ask that the court, based on what Mr. Steele has presented, just the fact that he doesn't think that it's admissible or it's a closing argument, that the court deny his motion that he not be allowed at all to use the PowerPoint.
all right. in fairness to Mr. Steele, he's ready to go slide by slide, and I asked him to summarize. So it's not that I asked him to summarize the argument. That's not all he would have to say. But this appears to me to have maybe originally been some sort of a law enforcement briefing. Is that what this was?
In terms of the investigation, of course, started out sort of as you know, them talking and law enforcement, various agencies talking amongst one another and briefing themselves. But in the end, this PowerPoint was something that was used by Detective Dennis in, you know, discussing the investigation with the district attorney's office, and that we believe as well would be useful in allowing the jury to digest pieces of information that he would be presenting through his testimony.
So tell me which slides you think you are absolutely concede are not going to be used. I mean, I'm just looking at one right now. It's, I think, slide number 36. It's got a lot of pictures, and it says a rap dispute between Lil Wayne and Birdman spilled over into Atlanta once rapper and YSL 30 Deep leader Young Thug got involved. I mean, how is that not totally conclusory and something that maybe this jury is supposed to be deciding? And that's just, you know, the one I happen to be scrolling onto right now.
Your Honor, the information that is in the letters, in the words rather, that are on the slide, we can see removing that as conclusory, but Detective Dennis has shared, and I believe would share information regarding what law enforcement learned throughout this investigation as related to not just the Lil Wayne bus shooting, but how that related to YSL and members of YSL, and what the artist that goes by the name of Birdman, what they learned.
So you're saying all the words would be removed?
Not on this slide right here. I'm not saying all the words, Judge. I want to be really clear. I'm not speaking about all the words. I don't think that it's necessary for all the words to be removed from this PowerPoint. But when the court asked me to tell or identify the ones that I conceived would be, you know, should be removed, I can, if the court permits me the time to go through it and look at those and pull those out, I can do that. But what we had was a whole hog objection to the entirety of the PowerPoint and an assertion that it was inadmissible overall.
Well, I mean, you're, I think at this point making the argument that you think it would be a demonstrative aid to, is this Dennis who's going to be testifying to this? And
we can sort of.
so let's look at like slide number 22. We've got people pictured up here who some, but not all of them were charged. I have no idea whether they were convicted. We got lots of shots of, you know, weaponry. There just looks like there's a whole lot that's not going to be appropriate or admissible. If you
So what we're looking at, the slide that I have.
can you pull that mic over towards you? I think some of the people are having a hard time hearing.
So the slide that I'm looking at as number 22, I think is different than the one that the court is looking at as 22. So I'm not certain why. I'm looking at one that has Miss Entrevia Smith, Kelvin Watson, Antonio Sledge on it. So it's different than the one that the court is looking at. I would ask that the court, if we're gonna.
And it's again, it's just kind of an example. So I think that maybe if this is going to have to be a slide by slide thing, that y'all get on the same page as to what PowerPoint you are even intending to use, and then you strike out, take out all of the ones that you concede and acknowledge are not admissible or would be overly prejudicial under the 403 standard. Take out all the words that you think that is not appropriate, and then get that back to me and I can look at it slide by slide. But
I think that would be good. I think I would ask for permission to do exactly that, Judge, as opposed to, because yes, I can do that, and I would ask for permission to do that.
okay, I'm gonna need that done by Friday.
Yes, Your Honor.
All right, so we can't do that today. We'll be doing that next week. All right, on the measure to suppress recently filed as to Mr. Ryan's statement from 2019, it looks to me now that it's been further particularized that there's an argument that he was not Mirandized. I don't know. I haven't seen the statement yet. I don't know if the state's position is he wasn't in custody at the time and therefore Miranda rights weren't required. I'm going to need an answer to that. I also need the statement from one side or the other so that I can have the benefit of actually being able to see the statement. Okay, so y'all get that to me as soon as you can. That ought to be an easy click something and send the email. And is the state, do you, I mean, I assume y'all are familiar with the statement they're talking about, and it was not used in his 2021 trial, but I think Ms. Love, you represented that you might want to use it in this trial. Is that right?
I did.
Okay. Do you know whether y'all's position is that he wasn't in custody, or do you know what you're going to be arguing on that?
Just 1 second, Your Honor. We were actually going back and forth, and I'm having trouble getting onto our server. That's what I'm trying to do right now. Can you pull it up? Are you on the server? Your Honor, could the court give me a 10-minute recess? I wasn't expecting to argue this part of it, and I just need to sign into our server.
I mean, I understand that all of this is on the fly at this point. We weren't going to take it up until next week, and now I'm trying to get something accomplished while we've got this unexpected free time. I don't think we need a recess for that. You just be working on that, and maybe I'll ask one of your co-counsel to address the next issue. Actually, I can ask, I can't see all the way around there. Is Mr. Harvey with us? Okay, who's here? Can you speak to, remind me your name? Try it one more time.
Lamar Gardner.
Okay, Mr. Gardner. Okay. Mr. Harvey had filed a couple of days ago a motion to exclude kind of, I guess, what he phrased untimely disclosed co-conspirator or alleged co-conspirator statements. Would you be able to identify specifically which co-conspirator statements he's saying were late identified?
I wouldn't be able to, but if you give me a minute, I can find out.
Okay. And then maybe today would be a good time to start looking at that exhibit list, and on the exhibits that there is not agreement on, kind of figure out, have those been admitted or have those not? Is that something you think we could all tackle today? We could try.
We can do the first part. We are almost finished with it, but we could do a chunk of it.
Okay. All right, I'm going to step off for just a second. Y'all stay here and keep working. I'll be right back.
little gaming channel. He's like my executive producer. He says, Tammy, come up. Tammy, do you want to hit the link and come up? Do you want to tell us about it? Dolores said, Tammy, come to the altar. I'm going to drop the link. I'm going to drop the link for Tammy. This is only for Tammy. If Tammy wants to come up and talk to us about this situation, only for Tammy. This is for Tammy.
People are like, Tammy about to have all of us pull up on him.
Thank you, Nikki, for letting us know. I'm gonna pin it. I'm gonna pin the link. Tammy, if you want to come up, you can certainly come up and hit the link. Let me pin it.
I'm so sorry that happened to her.
All right, guys. Hold on. Don't go calling Melnick. All right, don't go calling Melnick. Don't harass him, because Melnick, I'm telling you, his phone is ringing off the hook. Melnick's phone is ringing off the hook. So no one call and bother Melnick. Someone asked, David asked, why did Melnick get suspended? And this is what we were covering right here. AV got a hold of the order that suspends Melnick for 6 months.
Yes.
And so now all of it, let's assume, guys, that Melnick has, 200 cases. All of those cases need work. All of them. They're all going to need work in 6 months. Every single one. How can he do it? What if you hire, the great thing about Tammy is that she hired Tammy yesterday.
Yeah.
What if she had hired Tammy 2 months ago?
Yeah, and that's the thing too. Like, and put yourself in Tammy's shoes. Like, imagine if you see this attorney that's helping little Woody, that's sitting on the stand last week, like standing up against Love. He looked like he was doing a good job.
Yeah. So what are you supposed to do? What if you paid Melnick? And all this is assuming. Sassy says Fox 5 is at Melnick's office knocking. Oh my God. Y'all want me to go to Melnick's office? I ain't go to Melnick's office. Guys, man, Melnick is having a bad day. This is one of the worst days that this might be Melnick's worst day of the year.
They're saying the judge is back.
Oh, the judge is back? Okay, thank you. All right, let me.
Accidental motion. So I was reading.
It may just be the same title. I think this is the statement itself, which I had asked somebody to send. So thank you, Misty Williams. And I would think you would have been copied with the.
I'm sure I was. I
Okay. All right. If you're not already just generally familiar with it, that's fine. I'll look at the statement and wait for your response, and we'll deal with it on next week. Go ahead.
So the question the court had initially asked was it in custody, and
Right.
was it one that we intended to use? So the first part was it is a custodial statement. And it was one that we, for the sake of brevity, at one point we were pondering with not using it, but under the circumstances, he was convicted of this murder, and given that he was convicted of the murder, and the evidence we intended to put up in addition to the conviction, there were considerations we were making in terms of brevity. Like, do we use it? Do we not use it? Do we use portions of it?
That is fantastic to hear that y'all are making considerations based on brevity. I encourage that wholeheartedly. Go ahead.
And so, in as much as there's a need to have a Jackson Dental statement, just because of that possibility and that uncertainty.
Okay. Okay, but you're saying it was custodial and that he was Mirandized?
He was Mirandized. I think maybe the issue is that, the issue may be was it a full, like Miranda? Was it, like, was he fully apprised of his Miranda rights?
Okay, well, I mean, I guess we'll take that up next week. And I don't know, Misty Williams, was I misunderstanding what you said in your motion? I thought you said that he was not given any Miranda rights at all. Or warnings, not rights, but warnings.
Is this on? Okay. He wasn't given his full Miranda warnings at all.
Okay, but that's not exactly what you said in your motion.
And then also they have a procedure they're supposed to follow, and Detective Hogan did not follow those procedures.
Okay, that's also not in your motion.
Would you like me to redo my motion?
You don't have to redo your motion as long as I know what it is actually arguing. But I mean, you ought to try to get it right to begin with.
So we're going to be on the calendar for next week, Your Honor?
Yeah, but I told y'all that yesterday. That's not a surprise.
On Monday?
I don't know when we'll get to it. We're going to be working all week next week. Be prepared to deal with it on Monday.
Okay.
Okay. All right, so that's that. We'll deal with that on Monday. I have the statement now, so and I understand what your argument is. And if there's anything about a procedure that you mentioned that they didn't follow a procedural that they were supposed to follow, if you've got law that it's legally required, then please have that at the ready. All right. Okay. Do we know yet which of the co-conspirator statements are asserted to have been late disclosed?
Not the three particular that he mentioned in the motion, Your Honor. I'm still waiting on a response for the exact three statements, but I do know that those statements were provided outside of the November 5th, 2023. State filed a supplemental motion to introduce co-conspirator statements. I think in generally, he's objecting to any of them, any statements that were provided outside of that November 5th date. But speaking to the three that he mentioned in his recently filed motion, I still have not received that information yet.
All right, so we'll wait on that as well. And there's some, I think, allusion in there to wiretaps. So I don't know if there are statements that were contained within wiretaps. Okay. Well, we'll deal with that, I guess, further as well next week. Yes, sir.
Your Honor, on behalf of Mr. Stillwell, as the Harvey rule is in effect, my stance has been that, and really this has been my stance, and I believe it's other attorneys' stance since way back over a year ago, is the ball has been in the state's court to identify hearsay exceptions that they contend falls under the co-conspirator exception. They did file a motion that was timely that identified three, and we've discussed those three. But at this point at trial, and I know we discussed this last week, my recollection, and if I'm wrong, I apologize. My recollection is that we discussed this last week, and the state was to provide specificity on the statements that they plan to use. So
That's right. And
we still don't.
has
my
it
knowledge,
still
we
not
don't.
been done?
We provided a host of the states from the wiretap that we've identified, I think over 200. There's clips, there's small statements, but the point of it is that the statements contained with the wiretaps, within the wiretaps and the jail calls were statements that defense counsel referenced to the court were things that they were objecting to as we were ongoing, since they were all turned over and everyone had to review all the same batch of evidence. So we've turned over a number of statements that were contained within those wiretaps that count from our standpoint as co-conspirators.
Okay.
And that may or may not be what Mr. Sharp is referencing now. That is the only thing I can think that he's referencing now, since that's what we've most recently turned over for the court's instruction. And we're continuing to go through and make sure that we identify.
Okay. I mean, it ought to be that. I know that's not what you were referencing. You were referencing that there was a universe of 3 identified and dealt with, and now there's more. But with regard to what's in the wiretaps and jail calls, now that y'all have identified them with particularity, we can deal with them. I do think it sounded like y'all were sort of doing it in a rolling way with regard to some of that. So that's fine. We'll take those up individually. Are there any other potential co-conspirator statements that have not been particularly identified now?
So there may be others in the Instagram and in the phone dumps. And as far as the wiretaps and the jail calls, we had, as I said, provided a number of those, and we were supplementing as we went through and identified any more.
All right. Didn't I give you a deadline?
You did, and we provided.
You provided some by that deadline, but not all?
We listened to and provided, they are correct, there are thousands of things. And we have identified, we've gotten through up to a certain point, those wiretap calls. We have identified up to that point, and we were providing, since they had them, we were trying to at least identify as many of all of the ones that they have had since the beginning as we could. And we were continuing to supplement them as we saw them. We indeed went through, we have made the best effort that we can to comply with the court's instructions to identify those calls that we consider co-conspirator statements. We've been doing that with the wiretaps, the phone calls, the jail records, the phone dumps, and the Instagram records as well. So we've been continuing to identify those that fall into that category.
Okay, so you had a deadline, the deadline has passed, and I mean, at some point, a deadline needs to mean something. Why y'all don't already know what evidence you're going to use is beyond me, but.
And I can say that as a result of the volume of evidence that we have, we do and had identified, obviously, pieces of evidence that were more discrete, that were smaller in number. But as far as the wiretaps, of course, we've had teams working on it.
Okay, but I mean, the wiretap, that you said you've done that now. So what about the rest of it? The Instagrams and the phone calls, and you said there might be more in those.
We're still going through all of those. We've identified, and we literally created a link, and we have put them in the link and served them. And anything that we found or find past the point that we served the initial link, we are providing that as well. We are, from our position, of course, the court has given us a deadline. Of course, we're trying to comply with that deadline. When we provided information to the defense And in as much as there's something at the very end that, by happenstance, someone has seen that we have not yet identified, that we did not yet lay eyes on, that is in some way inculpatory. The volume of calls, our position is we turn it over, we should not be precluded from using it, but we are trying to comply with every instruction that the court has given us. We are making our very best efforts to do that. And we believe that as the court has said, we are aware that we have these ongoing obligations. This is not information that we've not turned over. This does not fall into that category.
Yeah, I understand that it is somewhere in the, universe of discovery that's been provided, but it has not been identified as here is a co-conspirator, what we assert to be a co-conspirator statement, because there is essentially a standing objection demanding that before anything gets admitted as a co-conspirator statement, the state establish the prerequisites for its admission as a co-conspirator statement. And so I have to make a ruling on each of those things. And until it's identified, I can't possibly make a ruling because we don't know what we're talking about. And I don't honestly think that my directive that there needs to be a deadline is the first one that's been issued in this case. I believe Judge Linville had also said this all needs to get done at this point.
As it related to the wiretap information and the information that we're going through now and identifying co-conspirator statements from, that was a matter that, just by nature of the way that we were proceeding with the case, that was addressed as we proceeded.
Okay. Okay. Well.
But we do have, and we have identified, and we can discuss, I think, over 100 if we were to start now and start
All right.
talking about them.
So at some point, there just has to be some kind of management of this case. It just cannot, I mean, I guess it could be, but it seems not practical that the case is going to go on forever because you're going to use every possible piece of evidence that you can uncover. I mean, that's no way to try a case. And it's not fair to the other side of any case to not know, for the most part, going into the trial, what the evidence is going to be. And I mean, we've had this discussion before, but y'all also, aside from that, y'all have got to kind of get a handle on what your case is going to be and decide what needs to be culled and what really needs to be presented.
Your Honor, the only reason that I can say that the reason that we want and feverishly seek to look at it all is that we don't want to be precluded in the event that, we don't anticipate playing every single co-conspirator statement that exists in these podcasts.
Right.
But in the event that there is one that is particularly important, and it's one that we didn't say by this date, oh, we're going to use this one, because we had not yet found that one, smoking call or whatever it is. Our position is just that it disadvantages that, just to an extent that we do not make a call. We feel that we should be allowed to at least access those that not hold all thousands of co-conspirator statements, but in the event that there are some, and we will narrow them down.
Okay. All right.
But we've identified ones that we.
All right. Well, get the rest of them identified and that identification information to the state. by the end of this week.
Your Honor, may I respond
Yes.
briefly, just so we're all on the same page? I don't mean to go tit for tat. That's not my intent here. But if the state is referring to the email sent to us on on August 9th of 2024, at 11:23 p.m., from what I can see, there's approximately 150 to 200 calls off the wiretap. They are not, some of these calls are 15 minutes. It's not about me listening to it. That's fine. I've already listened to this stuff. But just attaching a 15-minute call, a 10-minute call, doesn't necessarily indicate what co-conspirator statement you're intending to introduce. So there's just not a lot of specificity. Now, some of them are shorter.
My guess is, from what Ms. Love just said, she wants to cover all her bases. And so if there is anything said by that person in that call, she wants to be able to potentially use it. So I think she's saying every bit of it might be a co-conspirator statement. Am I wrong? I'm not wrong.
Well, if the intent is to litigate that, then I think I'm stating the obvious. It creates a whole lot of outside the presence of the jury litigation about stuff, because the state is not, and the state control this case. They controlled when to indict it, and they.
Well, y'all did file, I don't know who it was, but a speedy trial demand. But you're right, they indicted it. So they knew a speedy could have been filed and they needed to be ready. I don't know that everybody filed one, but did everybody?
I filed one. It wasn't recognized by the court.
You did not file one.
I did. But it
You're right. Yeah, I think it was within the period where everything was stayed. Is that what happened?
He filed a constitutional speedy.
No, I filed a statutory speedy.
Okay.
And
Anyway, at least some people have filed a statutory speedy that was recognized, and y'all are all being tried together, so that drug the whole case to trial at the same time. However, you're right that once the state indicted, they knew a speedy could be filed and needed to be ready to go, or either sever people out. It doesn't require a response. It's a statement of fact. Okay. So can we start on the exhibit list? I don't think there were that many that were in dispute.
Your Honor, excuse me, I don't believe we have the exhibit list yet. Is that correct, Ms. Hilton?
Oh, no. I mean, I'm sorry. I'm not being clear. One of the things that was proposed, I think by Mr. Steele, was why don't we take a chance to look at all of the exhibits that have been admitted so far and make sure we're on the same page about that. And I don't think there was that much dispute about that. So I'm thinking, let's do that right now. Y'all do have that, right?
The
Yes.
state was going to provide the list that we believe is the list of admitted exhibits. And so I'm getting ready to forward what we've created, but it's individual by the acts as they came in. And so I'm getting ready to forward that to everyone, but we were actually having printed copies brought down so that everyone could actually physically have one in their hand. And so that's what we were hoping will be down here by the time you finish, but I can forward what we have and it'll just take a little more time because it'll be electronic.
All right, so it seems that Mr. Steele's, what was it? It was like an Excel spreadsheet that was provided is pretty organized and orderly. Have y'all not tried to kind of match up what y'all have to that?
We have been matching that up. There are instances where electronic exhibits were shown to witnesses that we don't have a printed copy of to confirm that it was the exact exhibit that was admitted. There were instances where changes were made. There were multiple instances where the court required redactions, but we did not.
All right. So we're not ready on that either. So I think it may be that we actually need the prior court reporter in court one day for that next week. So why don't I figure out which day is the best day for her to do that? But that is something else y'all need to be ready to go with on Monday. So, I mean, I think I've been through my whole list of what's outstanding, and there doesn't seem to be anything we can accomplish today. Yes, sir.
If I may, Your Honor, last week we painstakingly went through transcripts.
Yes.
And redacted certain things. My understanding is that the state was going to have a printout. I think over our objection, their plan is to just pause the sound during redacted periods. But my understanding is they were going to provide a transcript with all the redactions after Your Honor's rulings, so we could review them and just make sure we're 100%. And if there's an issue, we're not bringing it to you at the last minute with the jurors in the box.
All right.
So I don't believe that we've been provided the redacted transcripts yet, or the state's version of the redacted transcripts, and we would like to at least have those so we could review them prior to the main play.
And is that correct that y'all plan to just pause the parts that are redacted? So y'all better be really good on the trigger with that. There are some parts where it's like, you know, part of a sentence, but not the next sentence.
Yes, Your Honor. Unfortunately, with evidence reviewer, it was a challenge to convert to the MP4 so it can be clean. It was distorted because we tried doing that previously. So that is the state's plan. I will send over the highlighted versions of the transcript that's redacted in a moment, as soon as I finish sending over the exhibit list.
Okay, so y'all can't just, there's no way that y'all can either put something together that is just the unredacted part or fuzz out the redacted part?
Does the court mean for the video?
I mean, I don't know how y'all are intended to play it. If you're intended, I don't know how you're intending to play it.
So, Your Honor, we're playing it through evidence reviewer, and we have successfully muted the portions of the video where it has continued to play in front of the juror, but it's very easy, and we have successfully done it on multiple occasions, muted the sound while the video continues to play for a couple of reasons. One, to allow the jury to see what's going on during that time, but two, to make certain they don't hear what is being said.
All right, so I'm glad to hear that it's muted at least, so there's no possibility or very little possibility that they'll hear something they're not supposed to hear. And so y'all have done that with video already where they're seeing that something else is going on that they're not privy to?
Yes, we've done that on multiple occasions.
And we also,
That's something that everybody agreed to?
No, we objected to that because it appeared to us that if the jury's sitting in the box and they're watching a video,
They're going, wonder what they're saying now.
Exactly.
So have y'all provided any explanation for that?
No, because the same way that if we were to cut it out and it skips to a part of the video, the jury would be wondering, wait, that didn't make sense. It skipped to an unrelated part. So even if we had the ability to cut out and cut and splice, it would be as choppy as it is.
Yeah.
And on other occasions, the jury,
So let me ask you this. If it's like a 2-minute redaction, are we just sitting in silence for 2 minutes?
No,
What's
generally,
going on?
We'll, in some instances, if it's a small redaction, we'll let it play. But like 2 minutes, we'll fast forward and say on the record, we are fast forwarding from here to here. We'll mute it and say, Your Honor, we're stopping at this point and we're picking up at that point. And that's what we do. We literally just take the advancing button and advance it to the point in the future that we're playing.
But let me just say, it really has not played out that smoothly in the past. Yes, there have been some occurrences where they've been able to mute it and it goes smoothly, but in other instances, yes, we're sitting here for 20 seconds, 30 seconds, and then in other instances where they try to skip ahead, they skip ahead, but then it's not quite far enough, or it's too far, then got to come back a little bit. So it hasn't been played out that
And I
smoothly.
mean, we got a lot of videos to get through, it sounds like. So can y'all endeavor to find out whether maybe even if you have to outsource it to somewhere else, you could put something together that's spliced, because that is a whole lot better than, I mean, it may sound like, oh, wait, that's weird, but that's better than, well, something's going on here.
So we've spliced, we have done that. We've actually taken the videos that have to be played through evidence reviewer, and we've formatted it, converted it, just as Ms. Hilton said, into MP4 format.
Right.
That does not play smoothly at all.
Okay, and I hear you saying that y'all do not have the ability to do that, but I mean, people put big multi-million-dollar trials on all the time. There are all kinds of outside, I don't know what they are, but companies who do things like this. Can y'all look into whether y'all can get that done? Because that would be a way, way better way to do it, both time-wise and in terms of the jury not seeing and wondering, well, what's going on right now? Both of those reasons. Y'all see what you can do about that.
Yes, Your Honor.
Okay. And while we're kind of just on the topic of that, is your plan to play, like, you know, for instance, we went through 5 statements, video statements of Mr. Copeland outside the presence of the jury to determine what parts were admissible and what parts were not. And Ms. Hilton, you've asked him about at least parts of all 5 of those statements. Is the plan ultimately to then play the entirety minus the redacted portions of all of those statements?
Yes, Your Honor.
Okay. All right. Okay.
Judge,
Yes.
can I, if I may direct a question to the state, just to make sure I'm clear. So we're talking about obviously the videos, but we're also talking about the redacted transcript as well, the actual physical transcript.
Okay. Now, I thought y'all had told me that no, you didn't intend to pass out transcripts like to the jury. Is that right?
Sure.
No, Judge, no. We said that we would correct the transcript
Right.
and redact them so that
For the benefit of the other side. We're not planning to give transcripts to the jury, are we?
no, no. We were asking to do that. I think there was an objection. I just wanted to be clear. We never said that we were not, because we would be asking that the court simply instruct the jury that the transcripts are not evidence. I think that when the objection was raised, it was that the transcripts were different.
Okay.
And that they didn't want them to be reading something that was not actually being said. And our position is that the court has the ability, and, you know, generally does instruct the jury, what you hear is the evidence, not what you're looking at. So
Okay.
that was the reason that that was another reason that we were endeavoring to get them as accurate as we could and to get an agreement on it. I thought that the court had said, before we give anything to
Right.
the jury, we wanted to get as much an agreement.
Y'all at
as we
least
could.
get agreement as to what everybody thinks is being said.
Yeah, our position was that we are absolutely objecting to the jury getting the physical transcripts. I think the discussions we were having was that once we had made a decision as to what was being redacted,
Right.
we were going to get a physical copy of the transcript. And so my question was, because I heard Ms. Hilton say a little while ago something about the highlighted portions, and I just wanted to be clear that I think what she is sending to us, and she can correct me if I'm wrong, is that they're going to send us the transcript, and perhaps the portions that have been redacted out are going to be highlighted so we can identify that. Am I correct about that, Ms. Hilton?
Yes, you are.
Okay. But if you intend to ask the court to let the jurors have a transcript as kind of a listening aid, I don't necessarily have a problem with that. I know that is what we all used to do back in the old days. And there are definitely things on all of these that are difficult to discern what's being said, but we all also recognize that the transcription of at least some people's statements was far less than accurate. So are y'all planning to have them retranscribed or corrected or something?
Yes, that is the reason that when I said any transcript before we even offer or ask to be passed out to the jury, we would correct and share with the defense and get some kind of consensus, even if it isn't an exact consensus, before we even ask the court to pass it out to the jury. The highlighted portions that Ms. Hilton was giving was just to aid in our discussions and agreement with regard to the redacted.
Okay, well, we got Mr. Copeland on the stand right now, and I hope that by Friday we are finished with him. Because that's a lot of days of one person's testimony. But if part of that is you're planning to play for him his statements to present him with his prior inconsistencies, they need to have seen the redacted videos, seen the redacted transcripts, and had a chance to review that for themselves and digest it. And it's Tuesday.
So before we attempted to pass it out, we would indeed give them time to digest it, understanding that it is Tuesday. We had been working on the redacted video portion, and that we were planning to do it one way, but the court.
Right. When do you expect to be able to get this to them? Everything that has to do with Mr. Copeland's video statements that are going to get played.
So, Your Honor, the state intends to give them 3 of the transcripts that has redaction, which what we talked about last week. I can provide that to them this afternoon.
Perfect.
As far as a transcript that we were going to give to the jury, the only transcript at this point that has been fully corrected and ready is the June 10th interview. So that's the only one that we would intend to give to the jury, is the June 10th interview. And we have that with the corrections that we will give to defense counsel today.
Also this afternoon. Okay.
As far as the video, we would have to find the outsourcing of it when we leave here today to determine how long that will take and if we can. If we cannot, then we're prepared to move forward in the fashion that we discussed earlier.
Okay. Well, that's definitely less than ideal.
It has not gone as bad as honestly, the playing, the pausing, the muting of the videos. The muting of the videos has not been the problem. It has been sometimes when it was when we were doing the MP4 that we were advancing and it was starting and stopping because of server issues.
Okay, it's still less than ideal. So I understand you're saying I may not be able to get this together in the next 2 days, but for all of the remaining witnesses, if you can't, honestly, if you can for him, I'd rather you do it for him as well. But I'm just sure that can be done. I'm sure there is somebody out there that can splice it as needed, but have it where it is still something that can be heard and understood. So, okay. So anything else? If not, I'll just go. Y'all can do your work and I can do things like other cases or listen to the statement or things like that to get ready for next week. So anything else today?
Your Honor, I'll file a particularized brutal motion for Mr. Kendrick's statement.
Okay, did you just file that today?
No, I will do it though. I have the.
Oh, you're planning to?
Yes, I have the timestamps like the court wanted.
Perfect.
I'm just trying to make sure it works, and I'll include other people here, and I'll send it to them first as a rough draft to make sure that I didn't miss anything for their clients. And then with regards to next Tuesday morning, just as a reminder, your honorable court has allowed me. I just wanted to.
Thank you for reminding me of that. And you'd be back with us by when?
I think I'm the second case on the calendar, so 12 o'clock. 12.
Okay,
But
all
I
right.
better check though their schedule.
Okay, so Mr. Steele had asked, and I had permitted him to. He's got an oral argument in another case before one of our appellate courts scheduled for Tuesday morning, and I had said yes, I'll excuse you to do that since I knew we were non-jury anyway next week. So then it sounds like both Monday and Tuesday will be starting, at noon instead of, or let's just say 12:30 instead of in the morning time. All right. All right. Okay, so let's adjourn for the day. We'll be back at 8:45 in the morning. Y'all have lots of work to do, especially y'all on this side. All right, thank y'all. It's not a surprise.
On Monday.
I don't know when we'll get to it. We're gonna be working all week next week. Be prepared to deal with it on Monday.
That's not good, Angela.
Okay. All right, so that's that. We'll deal with that on Monday. I have the statement now, so, and I understand what your argument is. And if there's anything about a procedure that you mentioned that they didn't follow a procedural that they were supposed to follow, if you've got law that it's legally required, then please have that at the ready. All right. Okay. Do we know yet which of the co-conspirator statements are asserted to have been late disclosed?
Not the three particular that he mentioned in the motion, Your Honor. I'm still waiting on a response for the exact three statements, but I do know that those statements were provided outside of the November 5th, 2023. State filed a supplemental motion to introduce co-conspirator statements. I think in generally, he's objecting to any of them, any statements that were provided outside of that November 5th date. But speaking to the three that he mentioned in his recently filed motion, I still have not received that information yet.
All right, so we'll wait on that as well. And some, I think, allusion in there to wiretaps. So I don't know if there are statements that were contained within wiretaps. Okay. Well, we'll deal with that, I guess, further as well next week. Yes, sir.
Your Honor, on behalf of Mr. Stillwell, as the Harvey rule is in effect, my stance has been that, and really this has been my stance, and I believe it's other attorneys' stance since way back over a year ago, is the ball has been in the state's court to identify hearsay exceptions that they contend falls under the co-conspirator exception. They did file a motion that was timely that identified three, and we've discussed those three. But at this point at trial, and I know we discussed this last week, my recollection, and if I'm wrong, I apologize. My recollection is that we discussed this last week, and the state was to provide specificity on the statements that they plan to use. So
that's right. And
we still don't.
Has that still not been done?
We provided a host of the within the wiretaps and the jail calls
Mhm.
were statements that, defense counsel referenced to the court were things that they were objecting to as we were ongoing, since they were all turned over and everyone had to review all the same batch of evidence. So we turned over, a number of statements that were contained within those wiretaps that count from our standpoint as co-conspirators.
Okay.
And that may or may not be what, Mr. Sharp is referencing now. That is the only thing I can think that he's referencing now, since that's what we most recently turned over for the court's instruction. And we're, continuing to, go through and make sure that we identify.
Okay, I mean, it ought to be that, I know that's not what you were referencing. You were referencing that there was a universe of 3 identified and dealt with, and now there's more. But with regard to what's in the wiretaps and jail calls, now that y'all have identified them with particularity, we can deal with them. I do think it sounded like y'all were sort of doing it in a rolling way with regard to some of that. So that's fine. We'll take those up individually. Is there anything, are there any other potential co-conspirator statements that have not been particularly identified now?
So there may be others in the, Instagram, phone, the Instagram and in the phone dumps. And as far as the wiretaps and the jail calls, we had, as I said, provided a number of those, and we were supplementing as we went through and identified any more.
All right, didn't I give you a deadline?
You did, and we provided.
You provided some by that deadline, but not all?
We listened to and provided.
Is anybody surprised?
There are thousands. And we have identified, we've gotten through up to a certain point, those wiretap calls. We have identified up to that point. We were providing, since they had them, we were trying to at least identify as many of all of the ones that they have had since the beginning as we could. And we were continuing to supplement them as we saw them. We indeed went through, we have made the best effort that we can to comply with the court's instructions to identify those calls that we consider co-conspirator statements. We've been doing that with the wiretaps, the phone calls, the jail records, the phone dumps, and the Instagram records as well. So we've been continuing to identify those that fall into that category.
Okay, so you had a deadline, the deadline has passed, and I mean, at some point, a deadline needs to mean something. Why y'all don't already know what evidence you're gonna use is beyond me, but.
And I can say that as a result of the volume of evidence that we have, we do and had identified, obviously, pieces of evidence that were more discrete and were smaller in number. But as far as the wiretaps, of course, we've had teams working on.
Okay, but I mean, the wiretap, that you said you've done that now, so what about the rest of it? The Instagrams and the phone calls, and you said there might be more in those.
Yes, we're still going through all of those. We've identified and we literally created a link and we have put them in the link and served them. And anything that we found or find past the point that we served the initial link, we are providing that as well. We are, from our position, of course, the court has given us a deadline. Of course, we're trying to comply with that deadline. When we provided information to the defense, and in as much as there's something at the very end that, by happenstance, someone has seen that we have not yet identified, that we did not yet lay eyes on, that is in some way inculpatory. The volume of calls, our position is we turn it over to not be precluded from using it, but we are trying to comply with every instruction the court has given us. We are making our very best efforts to do that. And we believe that as the court has said, we are aware that we have these ongoing obligations. This is not information that we've not turned over. This does not fall into that category.
Yeah, I understand that it is somewhere in the, universe of discovery that's been provided, but it has not identified as here is a co-conspirator, what we assert to be a co-conspirator statement, because there is essentially a standing objection demanding that before anything gets admitted as a co-conspirator statement, the state establish the prerequisites for its admission as a co-conspirator statement. And so I have to make a ruling on each of those things. And until it's identified, I can't possibly make a ruling because we don't know what we're talking about. And I don't honestly think that my directive that there needs to be a deadline is the first one that's been issued in this case. I believe Judge Linville had also said this all needs to get done at this point.
As it related to the wiretap information and the information that we're going through now and identifying co-conspirator statements from, that was a matter that just the nature of the way that we were proceeding with the case that was addressed as we proceeded.
Okay. Well.
But we do have, and we have identified, and we can discuss, I think, over 100 if we were to start
All right.
talking about them.
So at some point, there just has to be some kind of management of this case. It just cannot, I guess it could be, but it seems not practical that the case is going to go on forever because you're going to use every possible piece of evidence that you can uncover. That's no way to try a case. And it's not fair to the other side of any case to not know, for the most part, going into the trial, what the evidence is going to be. And we've had this discussion before, but y'all also, aside from that, y'all have got to kind of get a handle on what your case is going to be and decide what needs to be culled and what really needs to be presented.
So real quick, guys, I'm sorry to interrupt. I just want to make sure that I pause so we don't get too much audio interference because I know Love ain't using a mic right now. Are we surprised? And of course, there's more unpreparedness and we'll get back to that. But just real quick, an update from Tammy. She says that she called her bank and she's going to file an affidavit. So that's good. So Tammy, I'm happy we were able to point you in a good direction. So thank you so much for letting us know how that's going, Tammy. And of course, a lot of people are supporting you here. So we hope that this works out for you and keep us posted. All right, let's go back to some scrambling and scraping from Love. I'm going to bring it back about 10 seconds so we can hear what was happening there.
Kind of get a handle on what your case is going to be and decide what needs to be culled and what really needs to be presented.
Your Honor, the only reason that I can say that the reason that we want and feverishly seek to look at it all is that we don't want to be precluded in the event that, we don't anticipate playing every single co-conspirator statement that exists in the podcast.
Right.
But in the event that there is one that is particularly important, and it's one that we didn't say by this date, we're going to use this one, because we had not yet found that one, smoking call or whatever it is. Our position is just that it disadvantages to an extent that we did not make a call. we feel that we should be allowed to at least access those that not hold all thousands of co-conspirator statements, but in the event that there are some, and we will narrow them down.
Okay. All right.
Folks identified ones.
All right. Well, get the rest of them identified and that identification information to the state by the end of this week.
Your Honor, may I respond
Yes.
briefly so we're all on the same page? I don't mean to go tit for tat. It's not my intent here. But if the state is referring to the email sent to us on on August 9th of 2024 at 11:23 p.m., from what I can see, there's approximately 150 to 200 calls off the wiretap. They are not, some of these calls are 15 minutes. It's not about me listening to it. That's fine. I've already listened to this stuff. But just attaching a 15-minute call, a 10-minute call, doesn't necessarily indicate what co-conspirator statement you're intending to introduce. So there's just not a lot of specificity. Now, some of them are shorter.
My guess is from what Ms. Love just said, she wants to cover all her bases. And so if there is anything said by that person in that call, she wants to be able to potentially use it. So I think she's saying every bit of it might be a co-conspirator statement. Am I wrong? I'm not wrong.
Well, if the intent is to litigate that, then I think I'm stating the obvious. It creates a whole lot of outside the presence of the jury litigation about stuff because the state is not, and the state control this case. They controlled when to indict it, and they.
Well, y'all did file, I don't know who it was, but a speedy trial demand. But you're right, they indicted it. So they knew a speedy could have been filed and they needed to be ready. I don't know that everybody filed one, but did everybody?
I filed one. It wasn't recognized by the court.
You did not file one.
I did. But it was,
You're right. Yeah, I think it was within the period where everything was stayed. Is that what happened?
He filed a constitutional speedy.
no, I filed a statutory speed.
Okay.
And
Anyway, at least some people have filed a statutory speedy that was recognized, and y'all are all being tried together, so that drug the whole case to trial at the same time. However, you are right that once the state indicted, they knew a speedy could be filed and needed to be ready to go or either sever people out. It doesn't require a response. It's a statement of fact. Okay. So can we start on the exhibit list? I don't think there were that many that were in dispute.
Your Honor, excuse me, I don't believe we have the exhibit list yet. Is that correct, Ms. Hilton?
Oh, no. I mean, I'm sorry. I'm not being clear. One of the things that was proposed, I think by Mr. Steele, was why don't we take a chance to look at all of the exhibits that have been admitted so far and make sure we're on the same page about that. And I don't think there was that much dispute about that. So I'm thinking, let's do that right now. You have that, right?
The
Yes.
state was going to provide the list that we believe is the list of admitted exhibits. And so I'm getting ready to forward what we've created, but it's individual by the acts as they came in. And so I'm getting ready to forward that to everyone, but we were actually having printed copies brought down so that everyone could actually physically have one in their hand. And so that's what we were hoping would be down here by the time you finish. But I can forward what we have, and it'll just take a little more time because it'll be electronic.
All right, so it seems that Mr. Steele's, what was it? It was like an Excel spreadsheet that was provided is pretty organized and orderly. Have y'all not tried to kind of match up what y'all have to that?
We have been matching that up. There are instances where electronic exhibits were shown to witnesses that we don't have a printed copy of to confirm that it was the exact exhibit that was admitted. There were instances where changes were made. There were multiple instances where the court required redactions, but we did not.
All right, so we're not ready on that either. So I think it may be that we actually need the prior court reporter in court one day for that next week. So why don't I figure out which day is the best day for her to do that? But that is something else y'all need to be ready to go with on Monday. So, I mean, I think I've been through my whole list of what's outstanding. There doesn't seem to be anything we can accomplish today. Yes, sir.
If I may, Your Honor, last week we painstakingly went through transcripts.
Yes.
And redacted certain things. My understanding is that the state was going to have a printout. I think over our objection, their plan is to just pause the sound during the redacted periods. But my understanding is they were going to provide a transcript with all redactions after Your Honor's rulings, so we could review them and just make sure we're 100%. And if there's an issue, we're not bringing it to you at the last minute with the jurors in the box.
All right.
So I don't believe that we've been provided the redacted transcripts yet, or the state's version of the redacted transcripts, and we would like to at least have those so we could review them prior to the being played.
And is that correct that y'all plan to just pause the parts that are redacted? So y'all better be really good on the trigger with that. There are some parts where it's like, you know, part of a sentence, but not the next sentence.
Yes, Your Honor. Unfortunately, with evidence reviewer, it was a challenge to convert to the MP4 so it can be clean. It was distorted because we tried doing that previously. So that is the state's plan. I will send over the highlighted versions of the transcript that's redacted in a moment, as soon as I finish sending over the exhibit list.
Okay, so y'all can't just, there's no way that y'all can either put something together that is just the unredacted part or fuzz out the redacted part?
Does the court mean for the video?
I mean, I don't know how y'all are intended to play it. If you're intended, I don't know how you're intended to play it.
So, Your Honor, we're playing it through evidence reviewer, and we have successfully muted the portions of the video where it has continued to play in front of the juror, but it's very easy, and we have successfully done it on multiple occasions, muted the sound while the video continues to play for a couple of reasons. One, to allow the jury to see what's going on during that time, but two, to make certain they don't hear what is being said.
All right, so I'm glad to hear that it's muted at least, so there's no possibility or very little possibility that they'll hear something they're not supposed to hear. And so y'all have done that with video already where they're seeing that something else is going on that they're not privy to?
Yes, we've done that on multiple occasions.
And we also,
That's something that everybody agreed to?
No, we objected to that because it appeared to us that if the jury's sitting in the box and they're watching a video,
they're going, wonder what they're saying now.
Exactly.
So have y'all provided any explanation for that?
No, because the same way that if we were to cut it out and it skips to a part of the video, the jury would be wondering, wait, that didn't make sense. It skipped to an unrelated part. So even if we had the ability to cut out and cut and splice, it would be as choppy as it is. And on other occasions, the jury,
So let me ask you this, if it's like a 2-minute redaction, are we just sitting in silence for 2 minutes?
No,
What's
generally-
going on?
in some instances, if it's a small redaction, we'll let it play. But like 2 minutes, we'll fast forward and say on the record, we are fast forwarding from here to here. We'll mute it and say, Your Honor, we're stopping at this point and we're picking up at that point. And that's what we do. We literally just take the advancing button and advance it to the point in the future that we're playing.
But let me just say, it really has not played out that smoothly in the past. Yes, there have been some occurrences where they've been able to mute it and it goes smoothly, but in other instances, yes, we're sitting here for 20 seconds, 30 seconds, and then in other instances where they try to skip ahead, they skip ahead, but then it's not quite far enough or it's too far, then got to come back a little bit. So it hasn't been played out that
And
smoothly.
I mean, we got a lot of videos to get through, it sounds like. So can y'all endeavor to find out whether maybe even if you have to outsource it to somewhere else, you could put something together that's spliced, because that is a whole lot better than, I mean, it may sound like, oh, wait, that's weird, but that's better than, well, something's going on here.
So we've spliced, we have done that. We've actually taken the videos that have to be played through evidence reviewer, and we've formatted, converted it, just as Ms. Hilton said, into an MP4 format.
Right.
That does not play smoothly at all.
Okay, and I hear you saying that y'all do not have the ability to do that, but I mean, people put big multi-million-dollar trials on all the time. There are all kinds of outside, I don't know what they are, but companies who do things like this. Can y'all look into whether y'all can get that done? Because that would be a way, way better way to do it, both time-wise and in terms of the jury not seeing and wondering, well, what's going on right now? Both of those reasons. Y'all see what you can do about that.
Yes, Your Honor.
Okay. And while we're kind of just on the topic of that, is your plan to play, like, you know, for instance, we went through 5 statements, video statements of Mr. Copeland outside the presence of the jury to determine what parts were admissible and what parts were not. And Ms. Hilton, you've asked him about at least parts of all 5 of those statements. Is the plan ultimately to then play the entirety minus the redacted portions of all of those statements?
Yes, Your Honor.
Okay. All right. Okay.
Judge,
Yes.
can I, if I may direct a question to the state, just to make sure I'm clear. So we're talking about obviously the
Lead is back, guys. I'm sure everybody is eager to hear from you, but with court, it looks like they are wrapping up in about 8 minutes of court time. So you are muted.
I keep sugar streaming all day. All right, we'll finish this out and I'll tell you.
Okay, wonderful.
the videos, but we're also talking about the redacted transcript as well, the actual physical transcript.
Okay, now I thought y'all had told me that no, you didn't intend to pass out transcripts like to the jury. Is that right?
No, Judge, no. We said that we would correct the transcript
Right.
and redact them so that
For the benefit of the other side. We're not planning to give transcripts to the jury, are we?
no, no. We were asking to do that. I think there was an objection. I just wanted to be clear. We never said that we were not, because we would be asking that the court simply instruct the jury that the transcripts are not evidence. I think that when the objection was raised, it was that the transcripts were different.
Okay.
And that they didn't want them to be reading something that was not actually being said. And our position is that the court,
All right, let's go ahead and pause it because
generally does instruct.
we ain't gonna do y'all like that. We ain't gonna
Yeah,
do y'all
we're like,
that.
hold on, you're back. Tell us what happened.
Shout out to A Queen Is Born. Said, tell her to get Terrence Bradley. Talking about Tammy. And yeah, because there was some violations with Nathan Wade and the IOLTA accounts and all that. So shout out to A Queen Is Born. Thank you so much. And, I haven't done all the math, but I know that we have a new stream sponsor. Of course, shout out to the Little Gaming Channel. Says if it walks like a duck, looks like a duck, it's a fucking duck. It's a fucking duck. So shout out to the gaming channel. And guys, listen, I know I don't ask y'all for anything, but y'all have to understand this brother has sponsored not only whole streams, but whole series. And we've got over 10,000 people in here. So for the 10,000 plus people, please, somebody write TLGC in the damn chat. He is sponsoring the stream that you guys are watching. The stream with Woody, the stream with Melanie, the stream with Tammy. This has been such a crazy stream, and the Little Gaming Channel is sponsoring it all. So thank you so much to Little Gaming Channel. Excellent content creator. I am subscribed to him. I was watching his live stream a couple of days ago. Been subscribed to him for a while, but not only is he an excellent content creator, I'm going to tell all 10,000 of y'all plus that he is an excellent man, high value human being. And we're so happy that he was okay, as well as everybody else in California. Y'all had that, what I would consider a major earthquake, but I guess over there, y'all consider it a tremor, some 4.0, 5.0, 6.0 earthquake. That Little Gaming Channel on the 19th floor up there swaying his ass off. He was like, oh shit. Boy, in Georgia, we get little earthquakes, but they're like, 0.5, 1.1. So it's like, it's cozy. But y'all in California, y'all some real ones. So big shout out to everybody in California, but just a huge shout out to the Little Gaming Channel for sponsoring yet another stream. So thank you so much. And big shout out to all the previous sponsors as well. Of course, y'all see him. Oh, y'all saw him down there in the banner. Shout out to King of the South, Grudge Racing. Thank you. He was a stream sponsor, handing the baton off to the Little Gaming Channel, as well as Roy Williams, always coming in so heavy-handed. Legally Shay, thank you so much, Legally Shay, for supporting as well. And I'm going to change the banner in a second. So what happened? Well, when I picked up my phone, I noticed that Woody had sent me a text. So I texted Woody back, and then I called Melnick. As you guys can imagine, the call went through, but it went to it after it rang for, whatever times, it went to his voicemail. It's a Google number, right? So he didn't have any reason to try to dodge my number. But of course, the Google number said that his mailbox was full. Right? So everybody trying to get a hold of that man, everybody. And so I couldn't leave him a message. So then I sent Kayla a text, and I was like, hey, Kayla, I hope you're doing well. Had this lady come up. There's 10,000 people in the chat. She's saying things about Melnick. I don't know if you could have Melnick give me a call or otherwise contact me so that he can come on and kind of clarify things or give his version, because we all feel bad for Tammy, but we at the same time we have to acknowledge that we don't know Tammy. So we gotta stand on both feet. All right, we gotta be even-handed. Which is why I'm trying to contact Melnick in the first place to see, hey, this lady's, she's saying some inflammatory stuff. Do you want to try to clear it up? So I sent, first I responded to Woody, then I sent Kayla a text, and then I just emailed Melnick, basically saying the same thing. I sent Melnick the link. So if Melnick wants to hit the link, he certainly can. But I'm sure that Melnick is busy. So I called Melnick. I tried to get a hold to Melnick through Kayla. I sent Melnick an email, and then I also sent him a text. And the text and the email both include the StreamYard link if he wants to come up. But Variant says, man, listen, it's too soon for Melnick. And I would agree. Yeah. I would agree. Like I don't know one attorney that's been suspended for 6 months. It's such a devastating blow. It just throws everything off, everything. You've got all these court hearings, all these cases. Who's supposed to handle these cases? Who's supposed to handle these court hearings? Are you going to have to pay attorneys to show up? What happened with Kayla? Melnick said, hey, Kayla, I can't do this court hearing. Can you show up? Kayla says yes, doesn't charge anything, and look what happened to her. So the next